May it please your lordship.
Yes.
Lordship, I beg to mention for the listing of the writ petition on Friday.
Bench tree matter.
Bench tree matter.
This is the second bench tree. You have to go to Justice Surana.
Okay. Wait, the lordship, item 47,
Yes.
with the consent of the other side,
Yes.
this matter may be taken up after 4 weeks. The other matter pertaining to the challenge of rules is pending in court number 1, Lord.
47.
Yes, lordship.
Here for whom?
And for the respondent authorities.
Okay. You've taken the consent.
Yes, yesterday we had a discussion. He was supposed to be here.
What have you contended? What is your prayer?
The other matter where the rules have been challenged in the same.
There is another matter
Yes.
connected.
Yes,
Okay.
that is before court number 1, lordship. This matter would be taken up after that.
Okay. Miss A. Verma, Learned Counsel, appearing for the respondents.
For the NRL authorities.
For
Lord.
the NRL has submitted that the vagaries of the concerned rules are challenged, are presently under challenge before the Honorable Division Bench. And therefore, this matter may be adjourned, full stop para. In view of the above submission, comma, the matter is adjourned by 4 weeks. By 4 weeks. Liberty is granted to the Learned Counsel to make a mention in the event of a decision being rendered by the Honorable Division Bench in the meantime.
May I please, I beg to mention item number 3, my lordship. I have taken the consent from the other side, my lordship.
3 year for whom?
And for the respondent number 6, my lordship.
Why are you mentioning 15 matter?
My lordship, my senior is having some difficulty today. That's why.
No, who is your senior?
NN Sharma.
What difficulty?
My lordship is not here today. And 1 week, my lordship.
Where is he?
My lordship is not in Gossip.
15 matter, we cannot adjourn matters like this.
Actually, I have taken the consent of
Consent
other
is not
side.
material, madam. 15
lord-
matter after 8 years. Will consent be sacrosanct?
No, my lordship. It's only for a week, my lordship.
No, not a week. 15 matter. We'll give you time for a day. Make arrangements tomorrow.
Lordship. Oblige, my
Who is for the other side? Informed or not?
lordship. Inform my lordship. Arunabh Chaudhary, I informed him.
PD Nair is there. Where Mr. Arnab Chaudhary? Who is Arnab Chaudhary?
He told me. Is there-
Arnab Chaudhary. Okay, tomorrow.
Lordship.
A prayer for adjournment has been made on behalf of the respondent number 6. Full stop. The matter is of the year 2015. Full stop. Therefore, while declining the prayer for adjournment, comma, the matter is, short accommodation is granted, directing listing of this matter on Thursday, 2 more days. Thursday. Make
Alright, ma'am.
arrangements if he's not there.
Okay.
Thursday, huh?
May I please, your lordship?
Hmm.
Your lordship, I beg to mention item number 38 and 39. Your
38, 39.
Yes, sir.
Yes.
Your lordship, the arguing counsel, Mr. M. Ahmed, is unable to appear to teach personal difficulty. Matter may be adjourned for the day only.
You have taken the consent.
Yes, sir.
Agriculture Department.
Yes, sir.
Who's there? Agriculture Department. Consent from whom?
Your lordship, he is informed about it.
Okay.
Yeah.
It is submitted that Sri M. Ahmed, Learned Counsel for the petitioner, is having some personal difficulties today, and therefore a prayer for adjournment has been made. Full stop para. List after a week. 38, 39. Separate order.
File, your lordship.
Yes.
May I please, your
No interim order?
May I please, your lordship, with regard to item number 27, I had some personal difficulty today. That will be adjourned for the day.
21 matter. Okay.
I see.
BPC, BTWD is informed.
I've-
Sri A. Ganguly, Sri Atanu Ganguly, Learned Counsel for the petitioner has prayed for a short adjournment. Full stop. Para list after a week. 27.
May I please, your lordship, with the consent of the learned counsel of respondent lordship, may be part of lordship. So item number 13 lordship, may be listed for 1 week.
13. Of which year? Matter of which year?
2020,
Huh?
2020.
2020 matter. Why are you making a mention?
Personal difficulties of lordship not going to the file of.
20 matter.
Illness lordship.
After 4 years, where are you mentioning?
Sir, 20 lordship, thereafter lordship 22, 23 came lordship.
We are not on that. It's a matter of 4 years. We'll have it day after tomorrow.
Okay, lord.
Oh,
Along with WPC number 1784 lordship.
Your NH Laskar,
NH.
Sri NH Laskar, Learned Counsel for the petitioners. APDCL informed.
Yes, lordship. Yes,
Learned Counsel for the petitioners has submitted that there is a similar matter, WPC
1784,
1784,
2020.
2020, full stop, para. List this writ petition along with WPC 1784 on Wednesday. Date given.
Maybe 16 lordship,
Not 16th, 15th.
15.
Yes, day after tomorrow,
Hello.
15/5. Yes,
May please your lordship, I beg to mention the item number 28 with the consent of.
item number 20.
28. Here we have filed affidavit in reply. So 1 week time may be granted.
For why? Oh, you have
No.
filed already?
No, we have not filed.
You have to file.
Some conducting counsel Ali is not well. So
Okay,
that's
what
why
is your name?
C Talukdar.
Okay, you are instructed by Mr. Ali?
Yes.
Sri C. Talukdar Learned Counsel submits that a rejoinder affidavit is required to be filed, for which he prays for a week's time, full stop,
Yes.
para, list after a week. Yes,
I beg to mention item number 4, Lordship. I am appearing on behalf of Mr. MZ Ahmed, Senior Counsel. He has some personal difficulties today, so matter may be taken up tomorrow or day after tomorrow.
16 matter, okay, tomorrow.
Matter.
You informed the other
I'm
side?
there, my lord.
Okay.
Yes,
A short accommodation has been sought for on behalf of Sri MZ Ahmed Learned Senior Counsel for Coal India.
yes, Lord.
Coal India, full stop, para. Considering that the writ petition is of the year 2016, comma, matter is deferred till tomorrow. List tomorrow, list date, diva, huh?
Obliged, Lord.
I think on top of the list.
The subject matter is covered by recent decision of this honorable court, my lord. What has happened is, persons who are serving in the Central Reserve Police Force,
Hmm.
when they are posted in the Jammu and Kashmir area, left-wing extremist area or the northeast area, they are allowed to retain their family quarters at their last place of posting till their tenure in the north area or the
Or
other
these
area.
areas are complete.
My lord,
And that means they are not required to shift their family to this.
my lord.
Okay, madam,
My lord,
But what-
fact is something different, my lord, matter may be
What-
heard.
So, my lord,
Fact is
that is
different,
just
my lord.
the basic law I have stated. What has happened here is, petitioner was allotted a family quarter. He remained posted in different
okay,
areas.
we'll have this for final disposal today itself.
Yes, my
Yes,
lord.
my lord.
We'll finish up the other matters.
Yes, my lord.
And the second one,
Second, my lord,
top
I'm-
of the list. MH Ahmed.
I'm-
We'll give preference to your matter immediately after the orders are over.
Yes, may I
Yes.
please, your lordship?
Yes.
I'm appearing on behalf of RB Gora. In this matter, the PTC authorities claim some more time necessary instruction.
No 14 matter, madam, sorry. What is the matter about?
May I please your lordship? Lordship, my senior is on the way and we pass over the matter for time.
We'll have after some time. Ask a senior to be here. Okay. 14 matter. Yes, next.
Again, 61, so please. Order of step.
None appears for the petitioners on call, whereas Sri C.K. Sarma Boro, Learned State Council is present. The matter has been listed under the heading Order No Steps. as steps are yet to be taken for service of notice upon the respondent numbers 6 and 7, full stop para. An identical situation existed on the last occasion when the matter was listed on 6/5/2024, full stop. 6/5/24, when the following order was passed. To quote Kurujib. 6/5, huh? In view of the observations made in the aforesaid order, comma, this petition is dismissed for want of prosecution.
Lordship, 8 pieces. In this matter, Lordship, I had ordered it 26 for 2024. He was Director of the Instruction, Mr. P. Nayak. Because all the reliefs have been, Lordship, we have got all the relief except the notional benefit, my lord. Pursuant to filing the repetition, our promotion has been granted, my lord. Now we are working, I am working as the Deputy Director in charge, my lord.
Yes, Mr. Nayak?
On last day, Lordship, I placed my instruction. And wherein I stated that the proposal received from the department was returned for some
Which is your department, Madam, parent department?
food
Civil
and civil
Supplies and
supplies.
Consumer Affairs.
Accordingly, government was directed to obtain instruction. Clarify that.
Yes, government, Madam?
Both Deputy Lordship. No, Lordship, the letter has been written, Lordship, but no, we have not received any updated instruction. It was written on 3/5, Lordship. Lordship, kindly take it up on Friday, Lordship, and within this time I shall obtain.
But we'll dispose this off. This is a small issue remaining. Other issues have been resolved.
One DP was pending.
No, that was closed. Subsequently has granted promotion. They are not updated with the
One
instruction.
DP was pending in submission. That is why it wasn't clear to the first event. But subsequently, if the state of the that his promotion was given effect from the year 2016, whereas the petitioner was retrospectively given effect from. Why this, I mean, the difference is that clarification. The person who was promoted earlier, given subsequently, person who was promoted later has been given retrospective prior to that person. That
DP has
Otherwise, the
been dropped.
DP has been closed.
it's
No, we have got you. During the pendency of the DP, one junior person was promoted from a
Yes.
particular date.
Yes.
Suppose 2016.
16.
When the DP was closed, the petition was given promotion retrospective effect, but not from 16, from an earlier date, even from 15, suppose.
Right, that's
So why 15 now? Why not 16? Okay. Get the clarification.
Yes, Lordship, that's why I'm, but I thought I
On Friday.
Friday, Lord.
Okay. Heard Miss Bill Senior Counsel for the petitioner, who, by referring to the order dated 26/4/2024, has submitted that instructions were directed to be obtained by the Food, Public Distribution and Consumer Affairs Department, full stop. Para, Miss M. Bhattacharya, learned additional senior government advocate Assam, submits that though a communication has been made, appropriate instructions are yet to be received. And she accordingly prays for a little accommodation, full stop. Considering that this matter is of the year 2018, a short accommodation is granted directing listing of this matter on 17 hobo na 17th of May. 17th May.
Obliged.
Obliged. Your Lordship.
Yes, yes.
Item 6 and 7.
May it please your Lordship. In
Yes.
this matter, Lordship, this is regarding question of appointment of Anganwadi worker.
Okay.
Lordship, I was though selected as second Lordship position, but Lordship, the review respondent number 8 was appointed in her place, Lordship.
He was selected as number 1.
No, Lordship, number 2. Number
No.
1 is the outsider, Lordship. She was earlier, she was
No, you
appointed
said that you were at second position.
second position.
Who was the first position?
First position, one Aparna Devi, Lordship. She was
Appointed or not?
appointed, Lordship. She was outsider. So private respondent filed an writ petition before this court, and after that writ petition, Lordship, she was appointed on the basis of direction by this court, Lordship. And
Okay.
in that writ petition, I was not made party. So I have filed the review against that order, Lordship.
Okay. The review is pending.
Yes, Lordship.
We are
And-
considering the review.
Yes, Lordship.
What are your grounds?
Lordship, that I was not made party in the earlier writ petition, so the original documents were not placed, and the original select list was also not placed before this court, Lordship. After RTI, I came to know that I was selected as second position, and one Aparna
That will
Devi.
mean entering into the merits. Why didn't you file an appeal?
Lordship, I have not filed appeal as because, Lordship, I was not made party in that case,
You know what to do. You take leave to file an appeal.
Lordship.
You
But
take leave after
Instead
leave.
of that, Lordship, I have filed review, and Lordship, during pendency of review, they have filed one affidavit in opposition, private respondent, saying that there is a report that I am an outsider, Lordship.
You are
So
an
chal-
outsider.
Yes, Lordship. So challenging that report, Lordship, I have filed the second writ petition.
Which one? 4487.
Yes, Lordship. 4487, that writ petition I
Okay,
have.
that we can
later-
adjudicate.
Both are pending, Lordship. On last occasion, the official respondents were directed to place a record, Lordship. On 22/4, Lordship.
Who's appearing? For the this is social empowerment, women and social
Yes,
empowerment.
yes, Lordship. On last occasion also, when Lordship, the records were called for, I have stated before court that my submission was that, Lordship.
Madam
if there is a
Bhattacharya, we may not be too much inclined with the review, which Madam Chaudhary is paying for. But at the same time, an independent cause of action has been raised by way of the writ petition, wherein a challenge has been made to your decision holding her to be an outsider.
Outsider, Lordship.
Now, what is the basis of holding her to be an outsider?
There is a survey report, Lordship. It's a very short affidavit, Lordship.
You are for whom?
Private candidate, fine.
5. You are the selected candidate. In the merit list, what was your position? Third. But
He's outside.
Chaudhary's client, Joe, selected as 2, is an outsider, so is not eligible. Just
I already
like.
filed my affidavit, Lordship.
Hmm,
See,
But Lordship,
okay.
the same Gaupura gave certificate to private respondent and to the petitioner also, Lordship. May There I are many point- occasions, Lordship, it is seen that the Gaupuras, they issue various certificates like this.
Okay.
And these can be ascertained from the Latmondal or the circle officer, Lordship. And in the paragraph 3 of the affidavit, Lordship, there was a survey report by the department
Hmm.
regarding the residential status under the concerned Anganwadi center.
Right.
And then it was found that there are 47 members of family where the name of the family of petitioner was not found. This
Not
is
found.
there.
By report by whom?
The survey report by the department. And Lordship, I have filed my review, Lordship, may kindly see page 31. That is the merit list, Lordship. The private respondent's name was not there, Lord.
She private respondent is 3rd.
No, Lordship, kindly see page
No,
31.
what are you disputing that he is 3rd?
Lordship.
What is
first,
the official position?
Samsun Nahar got Lordship 47. This is a writ petitioner, Lordship, review petitioner.
Your name is Samsun Nehar.
Yes, Lordship.
And what is your name?
Dil Jahan.
Dil Jahan.
Dildahan.
Madam, regarding Dil Jahan's.
Nothing has been stated regarding this, Lordship. In the affidavit, nothing has been stated.
Where is your affidavit?
Then
You have filed in the subsequent writ petition. Affidavit, what have you stated that you are third position?
Lordship, regarding her residential status. I got an RTI reply from the
No, if, madam, if your eligibility is questioned
Lordship.
and there are materials to show that you do not actually belong to that area, then on your behalf, can we examine?
Lordship, may I submit contact if your Lordship that
And that too, these are factual matters.
Lordship, there is a decision of this court, Lordship, which says, Lordship, that if there is some disputed questions, Lordship can send it to the director and he may scrutinize the relevant factors of both the parties. Lordship. Okay, the same thing will happen.
They have a report. Where
Yes,
is the
Lordship.
survey report, madam?
Report has not been any, Lordship. It's,
That is the report you should put on records.
that your Lordship will find in the affidavit in opposition of the private respondent in review petition, Lordship. That is page 6, annexure A.
When was the recruitment process initiated? When was the appointment?
Lordship, 2016. 16, they filed one.
2016 appointment.
Yes, Lordship. Earlier writ petition order is dated 29/7/2016 and thereafter Dil Jahan was appointed, Lordship. Her writ petition was of the year 2013, Lordship. Before that,
Oh,
Lordship.
the recruitment process was of 2013.
13, Lordship. Advertisement of 2009, Lordship.
My
In
God.
Page 4 to para 3, I have stated.
Let us bring a quietus to this matters pending of Anganwadi worker from 2009. Where is the document?
Lordship, that's what Lordship.
Madam, in review, which page?
Lordship, affidavit in opposition filed by the private respondent. Annexure A, page C. For that only, Lordship, the records were called for.
Page 6.
Lordship, kindly take it after some time, Lordship. In the meantime, I shall check whether the records have come or not, Lordship.
Just a minute. Your name is Samsun Nehar.
Yes, Lord. The vernacular page 8, para 2 of the report, Lordship.
Yes, we have seen.
Yeah.
By CDPO.
Yes, Lord.
How is this verified? What are your grounds of challenge to this? You're challenging this
Lordship.
report.
Yes, Lordship. Para 5, the vernacular, your Lordship will find আনহাতে কর্মী পদৰ বাবে আবেদন কৰা মিস দিলজাহান
No, we are not on Dil Jahan. We are on your candidature.
Lordship,
Samsun Nehar.
I am saying that Lordship, I am from the same
No, no,
place.
what are your materials to show that you are a resident under this Jaberi Kuchi village?
Lordship. Lordship will take up this writ petition then. Lordship.
Okay, show us the material because that is the specific challenge that you are not an outsider, isn't it?
Yes, Lordship.
But what are your materials?
Lordship, the reply I have filed, a reply.
No, no, in
affidavit-
the writ petition.
In the writ petition, Lordship, I am saying that I am from the same place and I have a residential certificate of the petitioner, page 14, Lordship.
Page 14,
14,
14.
yes, Lordship.
No, this was considered by the CDPO who has given
Lordship.
that report.
Lordship, I have got the report.
No, no, I will come back, come to you, Madam.
Yes, Lordship.
See,
There
this
is
was
page-
this was page 14.
14, 15, Lordship.
14, 15 was the initial certificate on which you had relied
Lordship.
upon.
Yes,
Okay.
Lordship.
Thereafter, the report had come from the
The
CDPO.
report says, Lordship, the certificate was given by Bangshidhar Deka.
Yes.
But Lordship, kindly see the certificate which was issued by Deobar Deka. So how they came to Lordship came to know that Deobar Deka certifies petitioner or Bangshidhar Deka, Lordship. The report itself says on the basis of certificate which was issued by Bangshidhar Deka.
But this Deobor Deka is not from that village.
Lordship, it certifies that Eo Uttor Jabori Kuchhi
How
Super.
can he? He is from Dekargaon village.
No, Lordship. He is certifying the private respondent and the writ petitioner. This is the same person who is certifying, Lordship.
Where is the
In the review petition, I have annexed, Lordship. Both the certificate of the petitioner and the private respondent, Lordship.
Samsun
Page 13 and 15.
village? Dekargaon. Barampur. Dekargaon. Page?
13 to 15, Lord. Two certificates by the same person, Lord.
In the review.
Yes, Lord.
Thirteen to 15. This is for
Samsun Nehar
Samsun
by Deobar Deka.
of my area.
He is specifically written also, Eo Uttor Jabori Kuchhi Super Lutfal.
No, but while translating, where do you get this in the heading? Come to page 14, the original. Deobar Deka village Dekargaon. Then in your translated copy, you write village Dekargaon, Jaberi Kuchi, Balobara, Tuk. From where do you get this?
Dekargaon Post Office, Barampur.
So in the translated version at page 13,
Oh, Lordship, Balobara.
even Jaberi Kuchi.
Lord.
How do you get this?
But he is the Deobar Deka, Lordship. The same person certified. Your Lordship will find page 16 also. Translate, there are some mistake, Lordship. In the date also there is a mistake. So I am showing the vernacular. Lord. Certificate is dated 9/9/2009.
No, if there is a controversy of this nature, one same person has given a certificate in your favor as well as in the favor of the private respondent.
Lord.
CDPO clarifies the issue.
So my question is that, Lordship, the same person certifies that we are
No,
both from the same.
CDPO's report is not on the certificate of Deobor Deka. It is not a
Lordship,
certificate of
he's the-
another.
Lordship, we were never called by the CDPO, Lordship. On what basis he has
Madam,
certified?
let us see the report.
So I am challenging that report, Lordship. That's because the petitioner was never called by the CDPO, Lordship. How he came to a decision that Bamshidhar Deka certifies me, Lordship. When my certificate says it was issued by Deobor Deka, Lordship. So my humble prayer, your Lordship can set aside that report and direct them for a fresh Lordship survey.
So this communication 4/11/2019 is based on the report of 4/9/2015,
Yes.
which is the subject matter of challenge in the writ petition. That report, which is at page 23 of the writ petition, have you got 23? That report of 4/9.
If I
Of the writ petition, page 23.
Yes.
That is the report. Okay, see the date. This date is 4/9/2015. The relevant paragraphs are paragraphs 4 and 5. Please read.
That as per certificate issued by government Gapura, Sri Bamshidhar Deka, the address of the other three candidates, namely Ms. Samsun Nehar, Srimati Renu Deka, and Srimati Anjumani Saikia for the post of Anganwadi worker is village Jaberi Kuchi, P.O. Barkola Takwa, PSN Mauja, Kalaigaon, district Dara. Since the Jabekuchi Uttar Chuba Anganwadi Center is situated within the West Mangaldoy Child Development Project, it has been learned that these candidates are not the residents of the Anganwadi.
So this is against the
Center area.
petitioner. And the second part, page 5,
The
paragraph
other
5.
Ms. Diljahan Begum and Ms. Samtida Begum, who applied for the post of Anganwadi worker, are the residents of the Anganwadi Center area as per the certificate dated 10/9/9 issued by government Gabra Sri Deobor Deka, which Diljan Begum enclosed with her application. She is a resident of village Jaberi Kuchi, P.O. Barkola Sakwa Moja Sapai, Gao Panchayat Ramahari, PS and LSC Mangaldoy, district Darang, Assam. Furthermore, she has specifically mentioned that she is a resident of village Jaberi Kuchi, Uttar Chapua. It is remarkable that Srimati Aparna Devi, the selected candidate,
Not
and this-
required, not required. See, here we find names of two Gaumbura.
Yes.
So far as the petitioner is concerned, her certificate was issued by one Bongshidhar Deka.
Bangshidhar Deka.
And so far as the private respondent is concerned,
Deka.
that is by Deobor Deka.
Yes,
But
sir.
petitioner is annexing certificate by Deobor Deka. The certificates which are relied upon by the writ petitioner are issued by Deobor Deka. Now, is there any misrepresentation or incorrect representation of facts? What do you say? Where is your certificate?
The CDPO can verify that regard.
No,
Because-
you can just bring the records. Where is the certificate
Yes,
of
Lordship.
this
Yes,
Bongshidhar
yes, thank-
Deka?
Yes, Lord.
But these are matters of 2009.
In the merit list, Lordship, her name is not there.
Private respondent.
Yes.
No, no, that will examine only when you overcome the first hurdle,
Lord.
that you are eligible.
Lord.
If you are eligible, then definitely, if her name is not there in the merit list, then you may have a claim. But if you are not even eligible, on your behest, we may not allow, entertain your challenge.
But Lordship, appointment of Anganwadi for her, she must be teacher, section of the state particular Anganwadi center.
Correct?
But Lordship, in this case, the petitioner, she is not with the Anganwadi center of Saberi Kusur, she is from Saberi Kusur center. And this is my affidavit in the great petition, Lordship. And I have submitted two registered.
No, no, that certificate,
Yes.
which the petitioner is relying, says that she is a resident.
She may be a resident of Lordship,
No,
same
no.
village, but not in the jurisdiction of the Anganwadi.
No, she is Uttar Jaberi Kusir Subar. Permanent resident, she is the resident of Jaberi Kushi Uttar Suba Anganwadi Center.
Yes.
Of the petitioner, that is the language employed. You see her certificate. See her certificate. এও উত্তৰ জাবেৰী কুছিৰ সুবাৰ লোক হয়।
Now, Uttar Jabari Kusur.
Oh, madam, you have given,
Only.
you have
difference
added,
here,
you have
Lordship.
added Anganwadi Center.
Yes,
Lordship.
You have added Anganwadi Center in
Yes,
your
sir.
translation.
she was at
No.
Anganwadi center.
এও উত্তৰ জাবৰি কুচি
সুবাৰ লোক হয়।
And
Any see your translation?
Lordship
Jabari
translation,
Kusi
there are
Lord.
some
She
wrong.
is resident of Uttar Jabari Kushi Anganwadi Center.
Yes, sir.
Lordship,
Where do you get the center?
Lordship, some in the translation, there are some mistakes.
Yes.
Lordship, in both the vernacular.
But his vernacular, see, Miss Diljan Nessa Begum,
Till the
Jabari Kushi Uttar Subar.
Lok,
No. Uttar Suba.
Bakinder Lok.
There's something
There,
else.
there is a difference, your Lordship. In my certificate, it says Uttar Jaberi Kusi. And in his certificate, Jaberi Kusi Uttar. Uttar was written, Lordship, before Jaberi Kusi in my certificate. And in his certificate, Jaberi Kusi Uttar Subar Lokhay. Only that much difference, Lord.
No, regarding the center, Anganwadi Center.
There is
And
nothing.
in the report, your certificate has been stated to be issued by one, some other
Bongshidhar
Bongshidhar, not
Deka.
this Deobor.
Lordship.
Where do you get this Deobor?
No, Lordship, let them show my certificate, which certificate issued by Bongshidhar Deka, Lord.
Madam, we have not even filed affidavit. These are factual matters. If you're an affidavit, you have stated, we would not have entertained so much or gone into the merits.
Okay, regarding the review petition, let me get a point there. In paragraph number 14, Lord, they stated that the applicant stated while she was expecting her appointment, the applicant happened to meet Aparna Devi in market after 1 year. But Lordship, the petitioner submitted the impugn order in this honorable court order was passed in on 29/7/2016, Lordship.
That was
And-
taken from Aparna, Lordship.
And the certified copy was applied on 30/7/2016, Lordship.
No, we are not on the review. Review, we may
Yes.
not even entertain.
And the same order was annexed with the writ petition.
No, we are only on the writ petition where there is a specific challenge
Yes.
to a report by the CDPO dated 4/9/2015.
And regarding residence, Lordship, she is outside. She is from 78 number Dabarikuchi Center.
Lordship,
And I
if
got it from
government
a
file an
RTI reply,
affidavit
Lordship.
annexing my certificate by Bangshidhar Deka, Lordship, then I have no case, Lordship. Their report is only on
Where
the
are your,
basis.
where are your pleadings regarding your residential status?
In reply also, I have
No,
annexed some
in your petition,
writ petition, Lordship.
yes. Since the entire controversy is with regard to your residence,
Page 6, para 3, Lordship.
yes.
That the petitioner begs to state that out of in writ petition, Lordship. Above six applicants, the petitioner Samsun Nehar, Diljahan Begum and Tamjida Begum. Diljahan Begum is the respondent number 5, Lordship.
Hmm.
Are from same locality, that is village Jaberikuchi under Moja Chapai, which falls under the jurisdictional area of 22 number Jaberikuchi Uttar Suba Anganwadi Center. The applicants Renu Deka, Aparna Devi, she was appointed first, Lordship, Aparna Devi, and Anjumani Shaikia are from another locality, that is village Jaberikuchi Gusaigaon under Moja Kolaigaon. It is
Madam,
partic-
you are not disputing that the private respondent is also from the same area.
Yes, Lordship.
Only you are saying that she was not
Lordship.
in the merit list.
Lordship.
So
I
if
am
at
also-
all,
Lordship.
somebody has to be appointed because of the ouster of the first candidate, because he is not from the locality,
Lordship.
it is to be you.
It's me. If they can produce that Bangshidhar Deka certifies me, I am from the outside, Lordship, I have no case.
But you never challenged the appointment of Aparna.
No, Lordship, we are expecting, I have, in my
No, no, no.
review, I have.
If you
request-
say, if you think that Aparna was not from the locality, you
Yes,
should have been the first to challenge.
No, Lordship, I have not challenged, Lordship, I have made statement that I
At
was
that time,
expecting,
Lordship.
as she is outsider, she will be, Lordship, her service will be, Lordship, affected, and then I will be.
Affected because of
Lordship.
whom? Because of the private respondent.
No, Lordship. She is not in the merit list even, Lordship.
So, but her appointment was interfered because of an order of this court
Lordship.
in a
that is
petition
behind-
instituted by the
She
private
is not
respondent.
with the party, Lordship. If she is.
No, no, we are not on that. We understand that
Lordship.
this repeat, but you say that the private respondent was not even in the merit list
Lordship.
and you score a better mark than Aparna. Why didn't you challenge Aparna's
We are
appointment?
sure that Aparna's.
Because
has
there was
no
an
case-
appointment.
Yes, Lordship.
You did not challenge.
No, Lordship, I have not challenged. I was expecting that, Lordship, after Aparna, I may be appointed.
Without any
that-
challenge.
And that, Lordship, when Diljahan was appointed, then I made RTI, Lordship, and then I came to know that, Lordship, I am in second position. Lordship.
Since Lordship 2013 to 2017, the petitioner was a town council member at that time. And I have annexed the RTI
You are a
report
GP
in my
member?
affidavit, Lord.
GP member.
Yes,
Lordship, that-
2013 to 2017. It is available
Yes.
in my writ petition, affidavit.
You want to have the cake and eat it too. GP member, Anganwadi member, what else? Let there be equal
When
distribution of
government
wealth.
will File affidavit, Lordship, then your Lordship may decide.
We
Or
thought,
they can produce the record, Lordship, as there was already a direction.
we
to
thought
produce-
we'd pass that order, but right now we'll not pass that order. We'll dispose this of. Third, Ms. R. Chaudhary, Learned Counsel, for the both the review application and the writ petition being connected and filed by the same petitioner, comma, the same are taken up together for an analogous hearing and are being disposed of by this common judgment and order. Full stop. Clara? The facts projected is that a recruitment process was initiated in the year 2009 to fill up the post of Anganwadi workers less helpers in various centers, including the 22 number Jaberi Kuchi Uttar Suba Anganwadi Center under the West Mongoldoi Child Development Project in the district of
Lordship, if your lordship permit, there is another matter.
Yes, yes.
Obliged,
But we are dismissing
lordship.
in the district of Darang. Full stop. It is the case of the petitioner that she being eligible in all respect and had fared well in the selection should have been appointed. Full stop. However, comma, one Aparna Devi was selected against serial number 1 and was offered appointment. Full stop. It is alleged that the said candidate Aparna Devi was not a resident within the concerned center. Full stop. Para. The aforesaid appointment of the said Miss Aparna Devi was challenged by the present respondent number 5 by filing WPC 4470 of 2013. Full stop. It is submitted, 13, in which, however, the petitioner was not made a party. Full stop. The said writ petition was allowed by the order dated 29/7/2016, whereafter the respondent number 5 has been appointed. Full stop. It is the contention of the petitioner that she was in serial number 2 in the select list, and therefore in the event when the first candidate was held to be ineligible, comma, the petitioner should have been offered the appointment. Full stop. However, the respondent number 5, who was the petitioner in WPC 4470 of 2013, was given the appointment. Full stop. Accordingly, comma, the review application was filed. Full stop. In the meantime, comma, a report dated 4/9/2015 was submitted by the concerned CDPO holding the writ petitioner to be ineligible as she was not a resident of the particular Anganwadi center. And that has been said to be the reason of not offering the appointment to the writ petitioner, but offering the same to the private respondent number 5. And accordingly, the second writ petition has been filed. Full stop. Affidavits have been exchanged. Full stop. Para. I have heard Ms. R. Chaudhary, learned counsel for the petitioner, applicant. Full stop. I have also heard Ms. M. Bhattacharya, learned additional senior advocate, and Sri, your S. Sharma.
Yes, Adhyapak. Yes, Adhyapak.
As an Adhyapak. Your name is not there. Learned counsel for the respondent number 5.
Five.
Full stop. Para. Ms. Chaudhary, the learned counsel for the applicant petitioner, has submitted that the private respondent was not even a selected candidate, and therefore the appointment could not have been offered to her only because she was the writ petitioner in the earlier case, full stop. With regard to her challenge to the report dated 4/9/2015, comma, it is submitted that the petitioner has annexed the concerned certificate from the government Gaonbura, certifying her to be a permanent resident, to be a resident of the said, under the said center. Full stop. See, accordingly, the learned counsel accordingly submits that the review application should be allowed and the writ petition, both the review application and the writ petition should be allowed with a direction to appoint her client as the Anganwadi worker of the said center by interfering with the appointment of the respondent number 5, full stop para. Per contra, Ms. Bhattacharya, the learned state counsel, has submitted that the reason for not offering the appointment to the petitioner is evident, as the petitioner was not a resident under the concerned Anganwadi center, and therefore she will not have the locus to question the appointment made. Full stop. The anomalies in the certificates relied upon by the petitioner, including the discrepancies in the translations done, has also been highlighted by the learned state counsel. Full stop. A report, a communication dated 4/11/2019 made by the CDPO, comma, Pochim Momoldoi ICDS project to the director, comma, Social Welfare Department, has also been placed on record, as per which the writ petitioner is not a resident under the concerned Anganwadi center. Full stop. Para. Sri Adhyapak, the learned counsel for the respondent number 5, has submitted that the writ petition by his client was filed in the year 2013, challenging the appointment of one Aparna Devi, and the writ petition was pending for about for a period of more than 3.5 years, and there was no action of any nature of the petitioner at that point of time. Full stop. The petitions, the said writ petition WPC 4470 of 2013 was disposed of on 29/7/2016 and pursuant thereto, on 8/8/2016, comma, the respondent number 5 was appointed. Full stop. The review application was itself filed after a period of about 1 year, which is clearly an afterthought. Full stop. It is also contended by referring to the affidavit in opposition filed by the respondent number 5, comma, it is also contended that the writ petitioner was the Gao Panchayat member for the period 2013 to 2017. And the present approach of filing the review and the writ petition is clearly an afterthought. Full stop. Para. The rival submissions have been duly considered, and the materials placed before this court have been carefully examined. Full stop. Para. The primary contentions advanced on behalf of the petitioner is that the respondent number 5 was not a selected candidate, and in the event the eligibility of the candidate against serial number 1, Miss Aparna Devi, was found fault with by this court, comma, it should have been the writ petitioner who was required to be given the offer of appointment. Full stop. The petitioner has also relied upon certain certificates on the aspect of eligibility, qua the residential aspect. Full stop. To examine the aforesaid aspects, comma, this court has looked into the materials placed on record. Full stop. Though there are certain certificates which have been annexed with the review petition as well as the writ petition, comma, there anomalies are found both with the issuing authority and the translations made. Full stop. While the petitioner places reliance upon certificate issued by one Deobor Deka, comma, Government Gaubura of Dekargaon village, comma, in the translated version, comma, the village has been written as Dekargaon, comma, Jaberi Kuchi, comma, Balobara Tuk. Full stop. The aforesaid aspect has, however, been fairly admitted by the learned counsel for the petitioner. Full stop. What is also to be noted is that the report submits that so far as the petitioner is concerned, comma, her certificate has been said to be issued by one Bongshidhar Deka, Government Gaubura, and not Deobor Deka, as claimed by the petitioner. Full stop. The said aspect has also been clearly stated in the affidavit in opposition filed by the respondent number 4 on 29/11/2019, Full stop. In paragraph 3 of the said affidavit in opposition, comma, the following has been stated. Page 32, huh? Edu quote kore diba. No, eta blue hedi mari disu. Enake. Read khana, page 32. Full stop. Para. This court is of the considered view that when the eligibility of the applicant petitioner itself has been questioned and there are materials on record to justify such a view, comma, this court would not be in a position to make a roving inquiry into questions of fact. Full stop. This court is also of the opinion that an ineligible candidate would not have the locus to challenge the selection and appointment of another candidate. Full stop. In any case, comma, the residential status of the respondent number 5 has not been the subject matter of challenge. Full stop. This court has also taken note of the fact that the earlier writ petition instituted by the respondent number 5 in the year 2013 was pending in this court for a period of more than 3.5 years, when no steps action was taken by the writ petitioner. Full stop. The appointment of the incumbent Aparna Devi was also not challenged by the writ petitioner, was also admittedly not challenged by the writ petitioner, which prima facie demonstrates that the subsequent action of filing the review and the instant writ petition are afterthoughts. Full stop. Para. So far as the aspect of review is concerned, comma, the contours of entertaining or examining an application for review are well defined. Full stop. For ready reference, comma, the observation of the Honorable Supreme Court in the cases of so-and-so may be gainfully referred. Aribam to Didiba or Pisare to Didiba. Is the last order. 2 cases. Para. In view of the aforesaid facts and circumstances and the discussions made, comma, both the review petition and the writ petition are dismissed. No order is to post. Madam, you give a copy of this. We are retaining a copy.
That is lost. Well, in this case, my lord, the petitioners were appointed, my lord, in the district of my lord Bongaigaon Lordship by the Deputy Commissioner of Bongaigaon Lordship as junior assistant clerk.
Okay.
Now, my lord, their services were also confirmed by the Deputy Commissioner of Bongaigaon Lordship. My lord, during my lord creation of my lord PTAD Lordship, the villages, my lord, a part of my lord Bongaigaon district was my lord fallen under PTAD area Lordship, but 83 villages Lordship.
Left.
My lord, those villages were my lord outside the BTAD, my lord. For the work of my lord revenue matters Lordship, that those were functioning in the my lord Disney revenue circle Lordship. The petitioners were my lord looking after the matter, my lord taking care of those matters Lordship of 83 villages Lordship. Now gradation list was also my lord prepared in the district of Bongaigaon Lordship, Deputy Commissioner of Bongaigaon Lordship. Thereafter proposal came Lordship, their head of account, their my lord Everything will be managed by the my lord BTD. My lord, our opinion was called for lordship. We objected lordship. Thereafter, my lord, after filing objection lordship, my lord, a committee was constituted, and that committee, my lord, had taken a resolution, my lord, for creation of new, my lord, revenue circle, my lord, to look after the matter of, my lord, 850 villages of Bongaigaon district, which have been, my lord, looking at, my lord, taking care in the, my lord, business revenue circle lordship. Now, thereafter, lordship, a gradation list has been prepared, lordship, proposal was submitted, my lord, to, my lord, maintain their service, my lord, records in the Bongaigaon BTAD, my lord, and the head of account was transferred to the BTAD lordship. Now, after filing of this writ petition, my lord, 2 persons have already been, my lord, promoted in the, my lord, Bongaigaon district lord. Now, other 2, my lord, remains in the BTAD lordship. So this is a, my lord, case lordship. This is a, my lord, in one part, my lord, it is a discriminatory action lordship. On the same footing, my lord, 2 persons, my lord, during pendency of this case lordship, they have been given benefit lordship. Now others have not been given benefit lordship. Kindly see lordship, page 20 to the confirmation order. #21 lordship, annexer. Page annexer 3, page 21. This is a confirmed. One is a.
You tell us the facts chronologically. We are 14 matter. We are going for a disposal of this matter. Tell us the facts chronologically. Yes, let him place the case. We have had a rough idea of what is the matter.
Lost.
Yes.
Now kindly see lordship.
Just a minute, Mr. Ahmed.
Actually,
Yes.
I prayed for time for written instruction lordship. As per my perfect instruction lordship, and documents submitted by the petitioner, other in 1990 before creation of petition, and other after creation of 2000.
How many petitioners are there? 4. Okay.
Therefore, they two got promotion under the government of Assam, and other 2 lordship petition. Therefore, I am actually seeking time, authority or seeking time for the
14 matter, madam.
Yes, lordship.
10 years matters, we are not giving you time
Yes,
to
lord.
seek instruction.
Uh,
How?
kindly,
Can you take instructions by tomorrow or day after? Certainly not. You'll need at least 2 weeks time. We cannot afford to give 2 weeks for a 10-year-old matter.
Then
Sorry.
lordship kindly peruse page 9 of their APD.
Okay, you'll have your chance. Let him place the case. 4 petitioners.
On the other hand, my lord,
No,
I
no,
have
you
also
tell us the-
contact with the my lord petitioner.
Okay, still then, we'll have to do our job. 4
Yes,
petitioners.
lordship. Kindly see page 21, lordship.
4 petitioners. You were what?
Petition,
LDA.
writ petition, lord.
4 petitioners
4
LDA.
petitioners, my lord, 1 and 2 have been, my lord, already during pendency, my lord. Benefit is given, lordship.
No, no. They are. Tell us the facts first. They are LDAs.
Yes, lord.
Appointed as LDAs.
LDA, lord.
Junior assistant.
Yes, lord.
Where?
My lord, in Bongaigaon district, lordship, business revenue circle.
In business revenue circle. Okay, well then.
My lord, their services were confirmed by the deputy commissioner of Bongaigaon, lordship.
That was prior to the creation of BTAD.
My lord, after, my lord.
No, no, their
2014, this is
appointment.
2013.
Appointment.
My lord, kindly see confirmation order at page
No,
21.
appointment when?
One appointment is at 1990, lordship, before creation, my lord.
That is what
I have annexed, my lord, the appointment letter of the petition number 1.
before creation of BTAD.
Page
Okay.
9, lordship.
Of BTAD. Your appointments were confirmed.
My confirmed, lordship. That is at page 21 in 2000. This is 10/4/2013.
Appointments confirmed.
My lord.
This confirmation was by the government of Assam or BTAD?
Yes, maybe not BTAD, lordship. Deputy Commissioner of Bongaigaon, lordship.
By DC Bongaigaon.
Bongaigaon.
Okay.
Now, my lord, thereafter, my lord, in 2013, my lord, December, my lord, their head of account was transferred to BTAD, lord.
2013 December.
Yes, lordship. Business Deputy Commissioner.
Transferred to BTAD.
My lord, this is not, my lord, a clear lordship, but this is the business subdivision. Business lordship. Business subdivision. This is, my lord, Bongaigaon district, lord. My lord. Now, kindly see page 27, hearing was called for lordship as regards my lord transfer of their head of account and my lord their joining my lord maintenance of the traditional list in PTAD lordship.
Oh,
That was done my lord by letter dated 6/3/2014. This was my lord letter of the deputy commissioner lordship.
6-3?
6/3/2014 lordship.
Yes.
And then we submitted objection lordship, that is page 27. My lord, that objection hearing was there lordship. We personally also appeared my lord. Then my lord, a meeting was my lord on 25/6/2014.
Yes.
A committee was constituted in this regard lordship. A meeting was there my lord. That meeting lordship, there was a my lord resolution and proposal my lord to create new my lord revenue circle lordship to my lord take care of these matters of the my lord 83 villages which fallen under out of BTAD area lordship in the district of Bangladesh. My lord, we are also therein. We have been taking that matters lordship. Now a gradation list was also prepared on 28/6/2014 lordship by the deputy commissioner Bangladesh.
Of junior assistant?
Yes lordship.
Okay.
That is at page 33 lordship. We were there lord. Now my lord, after preparation of the gradation list of the my lord in the district of Bangladesh lordship, my lord, an order was passed by the Bangladesh lordship. Kindly see, selection committee was also constituted lordship. On the basis of that, my lord, gradation list lordship. Now impugn order lordship on
Selection committee for promotion to senior assistant.
Yes lordship. We were expected that our my lord claim would be considered lordship as per that my lord gradation list.
Okay.
Now impugn proposal, kindly see my lord page 39, 25/8/2014 lordship.
Page?
Page 39.
39.
Yes, lord.
Yes, please.
This is may I read lordship. This is written by the my lord deputy commissioner of Bangladesh. Subject: grade 3 employees of business circle and tehsil office in correction of names in gradation list thereof. I have the honor to inform you that the gradation list of grade 3 staff of amalgamated establishment of DC Moigaon published in compliance with order of Honorable High Court dated 21/11/2013 in WPC number so contains the names of 8 junior assistants as shown in the statement enclosed, who are now holding posts in the office of the business revenue circle and business tehsil, which was earlier in Bangladesh district before creation of Sirang district. However, these two offices are now in Sirang district under PTAD, though they still look after works relating to 83 villages of Bangladesh district non-BTA area. Both these offices were earlier under the administrative control of Deputy Commissioner of Bangladesh before creation of Sirang district, and the staff were originally appointed by the Deputy Commissioner of Bangladesh as seen from records. The salaries of incumbents of these posts are seen to be paid by BTAD Kukrazhar Treasury, but their names do not appear to have been included in the gradation list of junior assistants of CHOD junior joint DLR of BTC till date, though they now sorry, lordship, under the administrative control of BTC. The grade 4 employees working in these offices have meanwhile been included in the relevant gradation list therein.
They are now functioning.
Yes, Lord.
That word is functioning.
Yes, Lord. It should be, yes, Lord. It is functioning. It is therefore requested that these junior assistants be kindly be included in the gradation list of junior assistants at appropriate level of seniority under junior joint DLR BTAD to enable correction of the said gradation list of Bangladesh district The,
Okay, we have read this.
so this is, my lord,
There is a
for
direction,
correction, lordship.
direction for.
Now, four persons were, my lord, proposed to be corrected, lordship. Now, two have already been, my lord, given benefit of promotion in my Bongaigaon district, my lord. Then other two, my lord, this is a discrimination, lordship. On the other hand, lordship,
Which two have given promotion, have been given promotion?
for 1 and 2, my lord, petitioner numbers 1 and 2. These are, my lord, I have informed by additional affidavit, lordship.
So one and
Is-
two do not have any grievances on today.
Yes, lordship. My
Three and
4,
3 and 4 has the,
Yes.
have the. grievance.
Sandeshwar Burman and Pranjal Kumar Das have been promoted, lordship. Others two, my lord, have been. Now, the my lord, contention of the petitioners there. My lord, they were appointed by the, my lord, Deputy Commissioner Bongaigaon. They are working, my lord. They are functioning to take care of.
Mr. Ahmed, the petition number 3 and 4,
Yes,
they are similarly placed in
Yes,
as
lordship.
1 and 2. When was one was the date of appointment? Same date. Date of appointment as J.
date of appointment, lordship. Kindly see, lordship, that the annexer, additional affidavit, kindly see, lordship.
Yes, please see, give the date of appointment.
Sandeshwar Burman, junior assistant, lordship.
Yes.
This is annex, date of appointment 1990, lordship. I have annexed, my lord, in the petition also, lordship. Petition number 1, 1990, lord.
Then 2.
2, my lord. And appointment letter is not annexed, lordship.
3 and 4.
3 and 4, lordship.
Hmm.
I have annexed the additional affidavit, the additional list prepared, that is page 9, kindly see, lordship. This is the appointment, my lord, Aminul Islam, my lord, the petition number 3, on 3/3/2008,
Oh, you are much junior.
my lord. My lord, seniority, juniority, I'm not, my lord, questioning that, lordship. My lord, all
No,
the 4
Mr.
persons
Ahmed-
were, my lord, appointed
Mr.
by the
Ahmed,
deputy
Mr.
commissioner,
Ahmed.
lordship.
We can, after hearing, madam, we can ask, we can pass a direction for your inclusion of your names in the combined seniority list, gradation list.
Yes.
But admittedly, petition number 1 is much senior, 1990 appointee. And petition number 3 is 2008.
Yes.
So almost 18 years. We can ask them to consider regarding your, the
The
matter of your
point-
promotion in with regard to your seniority.
In Bongaigaon district, lordship.
Why not district?
Lord,
And what about P4, P2, P4,
3/4, my lord.
P4, petitioner 4?
Petitioner 4, my lord, that is on 3/3/2008, like all on same date, lord.
2008. Where is the order of 1 and 2?
1 and 2, lordship,
Additional affidavit.
additional affidavit annexer A, lord.
A. What is your name?
Serial number 9, lord, page 5, lordship, is the Sandeshwar Burman,
Is 1.
my lord, page 5, lord.
Is he 1?
Yes, lordship, page
P-
1.
P1.
Petitioner 1, lord.
And
And
Pranjit is
number
two.
2 is, my lord, Pranjit Kumar Das. He is at the serial number 12, lord. Last one, lord.
Okay. But 2 and 3 are yet to be given the appointment, the
Yes,
benefits.
lordship. In BT, my lord, Bongaigaon, lordship. My lord, issue is, my lord, whether they were entitled to be, my lord, considered promotion in Bongaigaon or my lord, BTAT, my lord. All the 4 petitioners are appointees under my lord, Bongaigaon district, lordship.
Yes, madam. Anything? We have noted that 1 and 2 have been given. We'll direct 3 and 4 to be given as per the seniority.
As per their seniority, as per their turn of the,
Okay.
and Assam women also file a petition. But court file a-
Who is 4?
Deputy-
What have you stated? What have you stated?
Lordship, I don't have the running page, Lordship. In the affidavit
What
paragraph,
have you stated? Just tell us.
paragraph 4, Lordship, it says that petitioners are working in the office of the business circle and in business tehsil, which is also under circle officer business, who is also tehsildar of business tehsil. The business circle as well as business tehsil are under BTAT Autonomous Council when this 6th schedule council established in 2003. On the creation of BTAD Council, revenue administration was transferred to BTC and consequently all posts in business circle and tehsil, including service of circle officer, BT and tehsildar was placed under the revenue department of the BTAD with the additional director of land records, Kokrajhar, functioning as the head of Department of Revenue Lordship. Pay and allowances of these staffs are being paid from BTAD since 2007. Though the petitioner originally appointed by the Deputy Commissioner Bongaigaon before creation of BTC Chirang district, they are now functioning under the control of BTAD administration. The grade 4 staff in the office of the business circle and tehsil have already been enlisted in the gradation list of BTAD under additional DLR Kokrajhar. However, grade 3 staff are yet to be enlisted under and these under process. The TLR BTC via his WT message dated 10/3/2014 asked the circle officer Bijni to provide the service details of petitioners. For inclusion in the gradation list of BTC, 83 villages of total 336 villages falling under business circle tehsil as that is, only 1/3 of the circle are not under the BTAD. The 83 villages have been attached to Bongaigaon Sadar Circle by government notification number so dated 39/2013. However, taking over the villages by the Bongaigaon Sadar Circle have been stayed by the Honorable High Court by this order dated 28/1/2014, pending disposal of the proposal of creation of a separate Manikpur Circle with 83 villages now under consideration by the government under Revenue Department. Then paragraph 5, Lordship, the deponent exercise.
Yes, we have read this. Madam Bora, you have also filed affidavit 3 by the Principal Secretary. There is an affidavit.
Yes.
Now, if
May-
the very simple query by this court is that if you could accommodate the petition number 1 and 2 for their inclusion in the gradation list, give them the benefit of their seniority, and subsequently promote them to the post of senior assistant, then why do you leave out the petition? number-
As per my that's it. That part of their names, their lordship, in fact,
Gradation list for which Bongaigaon,
for it-
BTAD?
because the graded stuff of it, if it's your, but yeah,
No, how could you give promotion to 1 and 2?
one, they have
Paragraph 9, Lordship, it is stated, Lordship. Paragraph 9 of the affidavit.
therefore, except of
But Mr. Ahmed, 2008, your appointment of 3 and 4 is made by BTAD.
yes,
My lord, no lordship, confirmation order that is
No,
by
no,
the.
No, no.
2008, 3 and 4.
And one more thing,
My lord,
Lordship, he
yes,
has,
my
How
lord.
can 3 and 4 be equated with 1 and 2?
Lord.
yes, that's why, Lordship.
My
he
lord,
should have
confirm,
filed a
kindly to
separate
confirm.
We are not on the
petitions, Lordship.
confirmation.
Yes.
You say that 1 and 2 were appointed in 2000 and 1990,
Yes,
whereas 3 and 4 are appointed in 2008.
as per instruction, their appointment also, my lord, was issued by the deputy commissioner Bongaigaon.
Whose?
My lord, the 3 and 4. lord.
Let us see.
My lord, that is, I have no copy of.
They have not annexed this.
No, I have not
Lordship.
annexed, my lord. It is clear, my lord. It is not a matter of mockery.
And
It is
he
clear, lordship.
should have filed a
I am,
separate
it is
petition,
not, my lord,
Lordship,
annexed,
for
my
all
lord,
of
the copy of.
petitioners
Now, my
separate.
confirmation, lordship.
own
He
document.
appointment is not, my lord, issued, my lord. Why the deputy commissioner will confirm, lordship? This is
Lordship, his
Bongaigaon.
own document. is
Where
additional
confirmation
affidavit.
Confirmation order, kindly see page 22, lordship.
of
Bongaigaon district,
of page
22, lordship.
of the writ petition?
Heat petition, lordship. One is Sanjeev Kumar Chaudhary. This is, one is 21, 2, my lord, number 5 is Aminul Islam Khandakar. This is by the deputy commissioner. Bongaigaon, lordship. Serial number 1, Sanjeev Chaudhary, Sandeep Pal Chaudhary, 5 is from the. Aminul
And this
Islam
is the amalgamated,
amalgamated establishment, my lord. My lord, the 83 village, my lord, is also, my lord, covered by the amalgamated establishment of the deputy commissioner, Bongaigaon, lordship.
no, if you are under the establishment of the deputy commissioner, obviously the deputy commissioner is the authority.
Yes, lordship.
But who appointed you?
My lord, Bongaigaon, lordship, deputy commissioner, Bongaigaon. This was issued in 2013.
No, your
And prior
appointment,
to in 2000
your appointment.
Yes, the appointment, my lord, I have not announced, my lord, then, my lord, I may be allowed some time, lordship, I will take. Next question, lord.
As per our this, practice, they are showing separate, seven from eight.
Page 2, paragraph.
Paragraph 4, second paragraph. Pay and allowance of staff are being paid. It's separate. So the
No,
originally
page.
page, so running page not like
Running page, you
Uh,
forget the running page, your page.
two,
2 paragraph.
paragraph 4.
That with regard to the statements made in paragraph 2.
Yes. And the second paragraph, Lordship, pay and allowance of the staff are being paid from BTAD since 2007.
The answer is has paid salaries under head so and so. No, that is not true. This is by whom? You are referring to the which affidavit? By filed by whom?
Sorry. And our 3, paragraph 3, Lord.
3. Not 3. Which affidavit are you referring to, madam? Filed by whom?
It is number.
See, there is one affidavit by respondent numbers 3, 6, 8, and 9. That is filed by one Biran Chandra Fukan.
Biren Chandra Fukan is our affidavit.
Yes, principal secretary. Which statement are you referring to?
Not in the second copy of the second help.
No, you are referring to, you are reading something else, which
It is actually different, not specific. Main question is, Lordship, they were appointed after creation of PCC, Lordship, so they are controlled under PCC. And other 2 partners, Lordship, they were appointed by a government of Assam, so they are appointed.
but Mr. Ahmed is
My lord,
is highlighting on the confirmation order.
Confirmation.
Yes. If they are appointees of the BTC, then the deputy commissioner confirming them.
Lordship, he has no annexed appointment letter of.
my lord, kindly see paragraph
Person,
3, lord, paragraph 3 of the writ petition, lord.
appointment
Last
letter
line,
not
last
by
sentence,
him.
lord. Paragraph 3 of the writ petition, lordship, last part, lordship, it is pertinent to mention that the petition number 3 and 4 were appointed by the deputy commissioner Bongaigaon after creation of district Sidang BTAD law. It is not denied.
But Mr. Ahmed, you could annex the appointment of one
Lordship,
petitioner.
I'm sorry for that.
No,
my
you
lord,
have not annexed.
my
What
lord,
is, what is it?
at the relevant time, lordship,
You could not, you should have not given
I may
a
be, my lord,
single appointment letter.
my lord,
Why are you selecting one appointment
my-
letter?
my lord, I may be allowed some time, lordship. I
2000, this matter of which year?
My lord,
14 matter, no?
14, my, in the meantime, I could not communicate with my petitioners, lordship.
You have done more than enough then.
My lord, now this is the, my lord,
Okay.
appointment is, my lord, stated, lordship. It is not denied, lordship, paragraph 3, lord. My lord, on the other hand, lordship, if I have not been appointed, lordship, why the deputy commissioner Bongaigaon will confirm, lordship?
Hard. Item number
2, lordship.
3. M.H. Ahmed, Learned Counsel for the petitioners. Also heard Miss M. Bhattacharya, Learned Additional Senior Advocate, Assam, and as well as Miss R.B. Bora, Learned Standing Counsel, BTC. Full stop, para. The claim of the petitioners is with regard to their fitment, is their proper fitment in the gradation list of junior assistant and a fair consideration for their promotion to the higher grade of senior assistant. Full stop. Para, Sri Ahmed, the learned counsel for the petitioners at the outset has submitted that from the materials placed on record, comma, the petitioner numbers 1 and 2 have already been considered and promoted to the post of senior assistant, and therefore the present claim is with regard to the petitioner numbers 3 and 4 only, full stop. It is submitted that while the BTAD was created, comma, there were 83 numbers of villages which fall outside the said BTAD, and the petitioners who were appointed by the Deputy Commissioner, Bongaigaon, were mainly entrusted with works pertaining to the aforesaid 83 numbers of villages. Full stop. However, comma, in December 2013, comma, the head of account was transferred to BTAD. Full stop. Though a hearing was conducted in which the petitioners had filed their objections, comma, objection, and there was also a proposal in a meeting of the committee on 25/6/2014 to create a new revenue circle, comma, the benefits of placing the petitioners in their proper position in the gradation list and subsequent appointment were not given. Full stop. Where it is contended that the names of the petitioners are present in the gradation list dated 28/6/2014, and a selection committee was also constituted for promotion to the rank of senior assistant. Full stop. Reliance has also been placed upon a communication dated 25/8/2014 by the Deputy Commissioner, Bongaigaon, to the Principal Secretary, BTC, to include 8 numbers of junior assistant in the gradation list of the BTAD with appropriate seniority. Full stop. As observed above, the petition numbers 1 and 2 have already been promoted, and the learned counsel for the petitioner prays for a similar treatment for the petition numbers 3 and 4. Full stop. Para. Ms. M. Bhattacharya, learned State Council, has, and by referring to the affidavit in opposition filed by the respondent number 5 on 15 December 2014, has however submitted that while admittedly the petitioner numbers 1 and 2 were appointed, has submitted that in the writ petition, the appointment order of the petitioner number 1 has only been annexed. And as per the averments made in paragraph 3 of the writ petition, comma, the petitioner numbers 1 and 2 were appointed on 19/6/1990, which was before the creation of the BTAD, whereas the petitioners numbers 3 and 4 were appointed on 3/3/2008, that is after creation of the BTAD, and therefore the cases of the petition numbers 3 and 4 cannot be held to be at par. Full stop. The State Council has, however, clarified that the names of the petition numbers 3 and 4 are included in the gradation list of the BTAD in terms of the letter dated 25/8/2014 by granting proper seniority as per their dates of appointment. Full stop. Para. Ms. R.B. Bora, the learned Standing Council BTC, has, while endorsing the submissions of the learned State Council, has informed this court that affidavit in opposition has been filed by the respondent numbers 3, 6, 8, and 9 on 8/2/2018. Full stop. It is submitted that it is reiterated that the mode of appointment of the petitioner numbers 1 and 2 is different from that of the petitioners numbers 3 and 4. And in fact, a common writ petition could not have been filed. Full stop. Para. Sri Ahmed, in his rejoinder, has submitted that the confirmation order of the petitioners numbers 3 and 4 in the year 2013 is by the Deputy Commissioner, Bongaigaon. Full stop. Para. Upon hearing the learned counsel and on examination of the materials on record, comma, it is not in dispute that the appointments of the petitioner numbers 1 and 2 were in the year 2019. 2000, not 19, 2009, were in the year 1990, which is much prior to the creation of the BTAD, whereas the appointment of the petitioner numbers 3 and 4 were on 3/3/2008, that is after creation of the BTAD. Full stop. This court has also been informed that in the common gradation list prepared by the BTAD, comma, the names of the petitioner numbers 3 and 4 are included. Full stop. Considering the aforesaid facts and circumstances, comma, this court, the present writ petition is disposed of by directing that based upon the seniority of the petitioners number 3 and 4, qua their dates of initial appointment on 3/3/2008, comma, their names are to be properly placed in the gradation list and in the event of any promotional exercise to the next higher post of senior assistant, their cases are to be duly considered on the basis of their seniority.
My lord, only provisions of my lord, rule 8, my lord, that may be kindly be directed to be followed, lord. My lord, rules 8 of the, my lord, Assam Ministerial Establishment Service Rules 1967, lord.
Why is it required?
That may be directed to be, my lord, followed, lord. This is, my lord.
By following the, by
My lord,
following-
it may be, my lord, observed.
why are you
Otherwise,
are you apprehending that they will not follow
my
it?
lord, question is, my lord, whether BTAD or by lord.
Lord, that be said by
That
the
is-
authority, Lord.
Yes, lord, that provision may be, my lord, directed. That may be, my lord.
Oh, in accordance with law, nothing else.
My lord, according to the rule 8, my lord.
That is not even the subject
My
matter.
lord, that may be specifically stated, my lord.
Sorry,
My lord, provisions of law, my lord, can always be.
we
my
have
lord.
sent provisions of law, that's all. We have
My lord, rule 8 kindly see, lordship. That is
Mr.
only-
Ahmed, we have passed the order.
My lord,
Yes, next.
provisions of law, lordship, can be, my lord, put it in the order, lordship.
1, 2. আরো কিটা আছে orders পালো নাকি এডমিশন ভোট আছে এডমিশন হে কোইডৰ সময় লাগিব না এই কিটা হেৰি নেকি একেটাটো আমি এইবিলাকতো পুৰণা গেছে আৰু প্ৰথমটো লৈ লওঁ আৰু কি আছে প্ৰথমটো লৈ লওঁ এক নম্বৰটো লৈ লওঁ
Lordship.
Okay, all matters are for disposal, so we are taking your matter. We'll give preference.
Obliged.
Where is your counterpart? Is she there? Yes, is there otherwise? Okay.
But immediately below my list, my synopsis, my lord, I had given a list of date and events, perhaps that would be to some extent convenient, my lord.
You tell us what are your facts.
My lord, petitioner, he joined his services as a constable general duty in the CRPF in 86 and thereafter was remastered as a driver.
When 1986?
He joined as a constable general duty. 1988, remastered as constable driver.
In 1988, there was a change in nomenclature.
No, not a name change in nomenclature. In service, people are given an option to become something else within the same force of the same rank. So from a general duty, he gave a test, he became a driver.
Okay.
Promoted in 1997 to head constable driver.
Now, 88 you said?
88, my lord, he became a constable driver. He changed his trade within the force.
Ever then?
And promotion to head constable driver in 1997.
Promoted to head constable
driver.
Okay.
In the year 1999, my lord, he was allotted a family quarter.
1999
at Group Center CRPF.
Where in Guwahati?
Guwahati.
Family quarter.
Family quarter, my lord.
At
thereafter, my lord, he was posted to Srinagar in 2002 to 2005. He remained in Srinagar. 2006, 2002 to 2005. Srinagar, Jammu Kashmir.
Yes, Srinagar.
Then, my lord, 2006, he came to Jorhat for a short time. 1 year. 2007, he was in Chhattisgarh. 2008, for 6 months, he was in Delhi.
Delhi,
my lord. And while he was in Delhi, 2008, my lord, the Central Reserve Police Force Family Accommodation Rules were introduced.
What is it called?
Central Reserve Police Force Family Accommodation Rules.
Okay.
Then, my lord, in 2008.
2008.
2008.
It was framed.
Just wait. 2009, my lord, the petitioner was posted to Rani Kamrup, Assam.
Mm.
While continuing to serve there, my lord, in 2012, he was given a notice for evicting the, for vacating the quarters.
Which quarter?
The one allotted to him in 1999.
2000?
On 11/1/2012.
Eviction notice.
Eviction notice. Thereafter, my lord, he preferred an application immediately 11/7/2012. He preferred an application that his children are studying
After 7 months.
after 6 months, my lord. And his children were studying, and that he should be allowed to retain the family quarter
Yes.
till the completion of the academic year.
Mm.
Then, my lord, 31/3/2014, his children completed the class 10 studies and he vacated the quarter on the same.
When?
31/3/2014.
14.
14, my lord.
Mm.
Petitioner's case, in the meantime, petitioner's case is that he had made the representation, he was asked to appear, he appeared, and no further communication was made to him, so he continued to occupy. Now, 31/3/2014, he vacated, and 1/4/2014, they pass an order for recovery of market rate rent.
Mm. Okay.
The first installment is recovered on June 2014.
Yes.
Thereafter, approaches honorable court, and my lord, in September 2014, the recovery was stayed.
Okay.
For the recovery was stayed.
This court had stayed.
My lord, yes. I approached in a repetition. It has been stayed.
How much was your first recovery?
My lord, it comes to around 6,000 and odd, my lord, per month, and it would
total?
amount to around 1 lakh. Amounts to 6,285 in 30 installments. Near about 1,80,000.
Rupees 6,000?
285 per month in 30 installments. Total recovery 188,537.
Rupees? 1
1
lakh? 1 lakh?
188,537.
1,88,000.
1,88,537
At the rate of 6,285.
at the rate of 6,285 into 30. Into 30. And this recovery is with effect from for the period of that lordship would find at page 32.
Yes.
Page 32, rupees 1,39,012 rupees for 25 to 13 to 31, 314, and 49,525 from 1,309 to 31,340.
Please come again.
My lord, page 32 it is given. Rupees 1,39,012.
Period.
25 February 2013 to 31st of March 2014.
Rupees?
And then
1,39,000.
1,39,012 rupees.
And
the next is 49,525 rupees
for
1st of March 2009.
1/3/2009
to 31/3/2014.
No,
But
that
this
is
49,000.
that is overlapping.
But this 49,525 I am not disputing.
49,000.
They can recover that amount from me because it was for family accommodation. That part I am not disputing.
No, the next period is overlapping.
Yes, my lord, what happened is,
1/3/2009 to 31/3.
yes, my lord, what happened is for that period, although I had occupied the government quarters, they had given me the family accommodation allowance also. So that part, my lord, I am not entitled to. I am not disputing that part. That 49,000 they can recover. No dispute on that. The only part that I was disputing is 1,39,012 rupees.
Yes.
So they say that I should pay my market rate allowance from 25th of February 2013 to 31st of March 2014. That is the only part they want to recover, a total sum of 139,012. The rest I'm not about. Dispute.
How much was the amount recovered?
Well,
Already?
they recovered for 3 months. They recovered around 19,000.
No, you said that June 2014, the first installment was recovered.
Yes, my lord, 6,235. Then, my lord, in September, I got my stay.
They had recovered 6,000 rupees.
In June, in July, they recovered 6,000. August, they recovered 6,000. September, I got it.
Then 3 installments recovered.
3 installments recovered.
You said first installment recovered.
The first was recovered in June. Then
No,
in
before the stay order,
3 installments have gone. Before the stay, 3 installments.
yes,
Petitioner's cases, as per the CRPF rules of 2008, a person when he is posted to any of these areas, Jammu and Kashmir, left-wing extremist or Northeast, he has a right to retain his quota that was allotted to him earlier. This has been settled by this honorable court, my lord, in a recent judgment, December 2023, that he is entitled to retain. Now, if the retention was, my lord, in accordance with law, or he was entitled to retain, then that period for which they're recovering my money, that, my lord, they cannot recover because I had an entitlement to retain the quota. And now the petitioner has also retired, my lord. He's out of service now. So at this stage, he has also vacated the quarters. Everything is done. They only need not recover anything from whatever is due to them. Lordship, para 8 of the document that I have done.
now this places of postings which you have referred
My lord,
after your allotment of family quarter at Guwahati,
my lord.
2002 to 2005, you are at Srinagar.
Yes, my lord.
Okay, that period is okay. 2006, you are 1 year at Jorhat.
I was at Jorhat. They did not require me to vacate the quarters. There was no notice. They did not ask me to vacate the quarter. Nothing happened. I came. Then thereafter, immediately I was sent to Chhattisgarh.
Not immediately, 1 year.
1 year, my lord. Yes. 1 year. There are times, my lord, when they sent us on attachment. If I am in, if I'm
1 year, you did not take steps to vacate.
To vacate, they did not ask me to vacate, and that is not their claim. Also, in their recovery order, that they want me to. They are claiming any rent for that period. They are not claiming any rent for that period.
Then 2007, you are at Chhattisgarh.
Chhattisgarh, I was entitled to.
2008, 6 months.
6 months in Delhi, my lord. That period, I was not asked to vacate the quarter. I did not vacate the quarter. They have not, in their order, they are not recovering rent for that period also.
So this recovery is from which period?
That recovery, lordship could find that was what I was reading out.
2025 to 2030.
13.
This is
Yeah,
from
13.
13.
25th of February 13 to 31st of March 14.
Where are you in 13 and 14?
My lord, Guwahati. Also in the northeast area. I was posted at 175 Battalion Rani. That falls within the northeast area. And therefore I was.
So, but your, the quarter which you were availing is also in the northeast area.
Yes, my lord.
It is not in somewhere in a
It is not.
non-sensitive area.
It is not.
Then,
My lord,
in Rani, you are also having,
the rules.
Rani, were you having an accommodation?
No. I did not have an accommodation in Rani at my field location. My quarter was at Group Center Guwahati, which is a secure location.
Madam,
175
madam,
battalion is a
if-
field location.
If he was posted in the period, let us concentrate on the period.
My lord.
25 February 2013 to 31st of March
2014.
Yes.
2014.
Yes.
This is the period where when he was working at Rani.
Yes.
And he was availing the quarter at Guwahati itself.
Yeah.
At where is it?
No mile, my lord.
No
9th
mile.
mile, Amerigo.
9th mile. Okay.
Yes.
Now, he was otherwise entitled to have a family quarter at that time. Was he not?
In Rani, madam.
Rani or wherever.
I don't have the instruction whether.
Rani
they
does not have family
if
quarters.
No, otherwise also,
Otherwise, yes,
his
madam.
family has to reside somewhere.
Yes.
Whether he is residing at Rani
Yes.
or because of non-availability of the function at Guwahati or anywhere else.
Yes, madam.
He gets,
Yes.
and he was posted in the northeast.
Yes.
So what is your basis of recovery?
My lord, basis of recovery is notice period, my lord. My lord, kindly see. Case number 7.
Your eviction notice is 11/1/2012.
Yes, my lord. 2012, yes, eviction notice is page 22, annexure 2, 11 January 2012.
And in 2009, you are not disputing that he was already in Rani.
Yes, my lord, that is not it.
Then what is the basis?
My lord, basis is that, my lord, in 2012, my lord, the notice was issued to him, my lord, to vacate the quarter, my lord. That is, it is also inform you that the Group Center Guwahati has issued the vacation notice by signal dated so and so on 7/1/2011. Earlier also notice was issued.
Okay.
In which it has been mentioned that you are in occupation of government family quarter number so and so more than 7 years, which are termed unauthorized occupation as per CRPF accommodation in CRPF.
So that is the question which
Yes,
you're trying
madam.
to pose.
After that,
Madam, listen to us. If you had recovered for 7 years or the period while he was in Delhi or Jorhat or anywhere else, matter would have been different. You have specified the period.
Yes.
It is from 2013, as we have just mentioned, February 13 to March 14.
Yes.
This period, you are making a recovery on what basis? We have to examine the order from the contents. This period does not relate back to a period while he was in Jorhat or no, Jorhat also he cannot for Delhi. The only period was
Only period was
Delhi. That
Only-
period you have not quantified or you have not mentioned. Now, technically going, you may have a case for the period while he had stayed at Delhi,
Yes, madam.
but you have not proceeded for 2008.
Yes.
When did you retire, Mr. Bar-
He retired in 2017, my lord.
2017, retired.
Yes. I do not have the exact date, but 2017. my lord.
You are a native of which place?
My lord, I am from Borpeta.
You are from this state.
My lord. I'm sorry, my lord, not Kamrup rural, man. Not Borpeta, Kamrup.
Doesn't matter, you are from
From
the
the state.
state. Madam, you can justify.
My lord, he submitted one representation, my lord, that is in page number 24.
Yes. 24 years.
Page number 24, my lord. Kindly refer to your officer's contact. Applicant regarding your letter is that one of my sons, Swami Akhtar, is studying in class 11 at the center school, and my daughter, Tanuja Akhtar, is studying in class 9 at the Montfort School near Group Center, 10th and certificate for your perusal is attached. As per paragraph 525 of the Family Accommodation Rule 2008, the period of maximum 5 years retention for family accommodation for CRPF employee and officer is not applicable when that is because he is taking the ground that in his daughter and son is class 9 and 11.
Now that is okay. Now let us come to the impugned order. What is the period? Is it a correct projection that is for the period?
Page 32, my lord. Page 32, the last four lines, my lordship, will say case remarks. Lordship will find. At
Well,
page
type
32.
copy is 31, that is.
No, typographical error টা এটা প্রিন্টাই ফেলতে হবে। Original is at page 32 in exercise.
Which effect from 25 to 13 to 31,
Wait,
3, 2014.
That is my only good.
Your action which culminated in this order is not relatable to the allegation. Order of 1/4/2014. Is it 1/4/2014?
Yes, madam.
This is the area of the see the period in
The
mentioned.
Period is 25 to 13 to 31. 3,
How is it
2014.
connected?
That is from the date of notice to the date of
And he is not
petition.
disputing this 50,000, 49,000 odd. Out of 188, he will give 50,000. Then remaining around, say, how much? 138. 138.
My lord, the date is, my lord.
He'll pay the 49,000 odd minus what has already been deducted. 6,285 into 3. Around 20,000 you have deducted.
Out of the
Two,
out
two,
of the
two.
49, 20,000 has gone. Another 30 day will take the rest.
My lord, that period is 25 to 2013 to 31. That is from the date of notice to the date of actual date of petition. That is the period. Sir.
So that can you, otherwise he was entitled in that period to retain a quarter. He was in Kamrup. So if he was entitled, can you pass an order of penalty? Okay. The challenge in this writ petition is with regard to an order of recovery of a total amount of rupees 1,88,537 which includes an amount of rupees 49,525 which was the housing allowance given to the petitioner. Full stop. The recovery has been sought to be made in 30 installments at the rate of rupees 6,285. Please have your seat. And 3 installments, and this court has been informed that 3 installments have already been recovered. Full stop. However, in view of an interim order passed by this court on (24/9/2014), no further recovery has been made. Full stop. Para. To resolve the controversy, the essential facts are liable to be may be narrated in the following manner. Full stop. Para. The petitioner was appointed with the CRPF in the year 1986 as a constable general duty. Full stop. By following the procedure, in the year 1988, he was posted as constable driver, and subsequently in 1997, he was promoted to the post of head constable driver. Full stop. It is projected that the personnel of the CRPF are entitled to family quarter, and in the year 1999, such a family quarter was allotted to the petitioner in the group center, 9th mile, Jorabat. Full stop. For the period 2002-2005, the petitioner was posted at Srinagar, semicolon. In 2006, he was posted at Jorhat for 1 year, and in 2007, he was posted at Chhattisgarh, and thereafter, in 2008, at Delhi for about 6 months. Full stop. The petitioner was posted at Rani in the district of Kamrup in 2009. Full stop. On 11/1/2012, an eviction notice was issued to the petitioner in connection with the family quarter under his occupation. Full stop. The said notice was replied to by the petitioner by stating that his children were who were school students were required to complete their academic session. Full stop. Ultimately, on 31/3/2014, the quarter was vacated. Full stop. However, wide the impugned communication dated 1/4/2014, recovery of rent at the market rate as indicated above was sought to be made. Full stop. It is this action which is the subject matter of challenge in this writ petition. Full stop. I have heard Sri R. Mazumdar, learned counsel for the petitioner, whereas the respondents are represented by Ms. A. Gayan, the learned CGC, who submits that affidavit in opposition has also been filed on 19/1/2015. Full stop. Para. Sri Mazumdar, the learned counsel for the petitioner, has referred to the CRPF Family Accommodation Rules 2008, as per which, in the event a personnel is posted in the sensitive locations of the Northeast India, Jammu and Kashmir, and Maoist infested
left-wing extremist area,
they are entitled to retain the family quarter. Full stop. He submits that except for a short stint of a year in the year 2006 at Jorhat and 6 months at Delhi in 2008, the petitioner has all along been posted in the aforesaid sensitive areas, and therefore he was entitled for retaining the family quarter. Full stop. He submits that at no earlier point of time, especially during the aforesaid stint at Jorhat or Delhi, any notice was served upon him to vacate the quarter, and such notice was only served on 11/1/2012 when the petitioner was already posted at Rani, Kamrup from 2009. Full stop. He submits that there was no basis for issuing the said eviction notice, and consequently the action to recover is bad in law and without any jurisdiction. Full stop. Para. Coming to the impugned communication, the learned impugned communication dated 1/4/2014 dated. The learned counsel for the petitioner has submitted that the period specified in the notice is 25/2/2013 to 31/3/2014, and in the said period, the petitioner was actually posted at Rani, Kamrup, which is, and therefore entitled to retain a family quarter. Full stop. The learned counsel has, however, admitted, has however fairly admitted that so far as the component of payment of housing allowance for the period 1/3/2009 to 31/3/2014 is concerned, concerned, amounting to rupees 49,525/ is concerned, he may not have a dispute, as admittedly in that period, the family quarter was under his occupation. Full stop. However, the amount of rupees 1,39,012, which has been sought to be recovered, is submitted to be absolutely illegal. Full stop. The learned para. The learned counsel has also informed this court that in the year 2017, the petitioner has retired from service, and therefore the order of recovery would otherwise be harsh and would cause immense hardships to the petitioner. Full stop. The learned counsel has relied upon an order dated 12/12/2023 of this court passed in WPC 5357 of 2012, wherein interference was made in a matter of similar nature. Full stop.
In that case, the eviction was interfered with. The market rent cannot come into play, the eviction itself was interfered.
Or has referred, relied upon a decision of this court wherein an action of eviction of personnel similarly situated was interfered with. Full stop, para. Per contra, comma, Ms. Gayan, the learned CGC, has submitted that it was the duty of the petitioner to have vacated the premises when he was posted in a non-sensitive location. Full stop. It is further contended that the eviction notice was issued on 11/1/2012 and the quarter was actually vacated on 31/3/2014, and therefore the impugned demand is wholly justified. Full stop. The learned counsel for the respondents has, however, fairly submitted that the period mentioned in the impugned notice is 25/2/2013 to TO2, 31/3/2014, in which the petitioner was posted at Rani in the district of Kamrup, Assam. You retired from Rani?
Right, Rani.
Okay, full stop, para. The rival contentions have been duly considered. Para. Upon hearing, comma, upon hearing, the rules of 2008, and there is no dispute that the rules of 2008 stipulates a situation wherein a personnel of the CRPF could retain the family quarter if he is posted in sensitive locations as indicated above. Full stop. This the records would reveal that except for a period of 6 months in the year 2008, when the petitioner was posted at Delhi, comma, all along he has been posted in the sensitive areas. Full stop. The family quarter was allotted in the year 1999 at the group center, comma, Jorabat. And there is nothing on record to show that prior to 11/1/2012, comma, more specifically in the year 2008, when the petitioner was posted at Delhi, comma, any such eviction notice was issued. Full stop. In fact, it appears that when the eviction notice was issued on 11/1/2012, comma, the petitioner was posted at Rani, Kamrup, Assam, wherein it has been stated that there is no provision for family quarter. Full stop. What is also to be noted is with regard to the period specified in the impugned notice, which is 25/2/2013 to 31/3/2014. When full stop. When there is no dispute that during the aforesaid period, the petitioner was actually posted at Kamrup in the state of Assam and was entitled for a family accommodation, the action to recover the amount for the said period does not appear to have any basis or logic. Full stop. This court has also noted that so far as the amount of rupees 49,525 slash dash is concerned, the same is on the account of housing allowance, which the learned counsel for the petitioner has fairly submitted that the same would not be disputed. Which, full stop. Para? No, para no. This court has also noted that the petitioner had retired from service in the year 2017. Full stop. Para? In view of the aforesaid discussions, this court is of the opinion that in the interest of justice, the following directions are to be issued. Full stop. The demand for recovery of rent for the period of 25/2/2013 to 31/3/2014 wide the impugned order dated 1/4/2014 is set aside. Full stop. However, the petitioner would be liable to repay the amount of rupees 49,525 slash dash, which is the housing allowance. Full stop. This court has also been informed that prior to the interim order passed by this court, 3 installments at the rate of rupees 6,285 were already recovered. Full stop. The aforesaid recovery would be adjusted with the amount of housing allowance as indicated above. Full stop. Writ petition accordingly stands allowed in the manner indicated above. No order is to cost.
Obliged.
Itu itu thing about it. Yes. He did. Like that. Hold on. অফ কৰি এচিটো নালাগে পিছত দিব ঠাণ্ডা Yes, please.
My lord, in this case, the last packages of the direct made to some record file. Even to documents.
Oh, that master roll workers case.
Yes, fine.
Yes, madam.
The last. Fixing.
Those discrepancies in the two documents.
Their lordship, I have got the issue register also on the same day that
Yes.
both the letters were issued, lordship.
Okay.
Lordship,
Now, what is your instruction?
we have got the letters, lordship.
Yes,
It's
yes.
flag mark.
Yes.
Flag mark the 3 letters.
Okay.
It's there,
Issued.
lordship. Issued, the first letter, which is the audit, like, for the 7 numbers were
Okay.
working, lordship, the letter is issued. On the next 43 other master work.
Those are, that is also separate letter what? Here, which pages?
Last in segment.
Big flags.
Last
Okay.
pink one.
Okay, okay. Mhm.
But lordship, we were on the reference letter dated 15/12/17, lordship, in both the letters. The reference was of the letter dated 15/12/17, which gives the status report of only the 7 numbers of MR work.
Something is there, madam. Something is there.
In the district,
You see both the letters, the fonts are different by the same district agriculture officer. The handwritings are different. Why?
that is
The mode of writing, the date is different. There is overwriting.
and in district record lordship discloses.
And
the-
even the issuing 798 7 38 9849 9850. Where is your 228? Letter?
228 is page number 163 of my affidavit.
No, in the record?
228 there.
No, there are anomalies in the handwriting, but there is a connection. 228 is followed by 228 is in connection with 7 numbers. You are 7 numbers.
No, but
You
Lordship, that the
Yeah,
reference
43
was
number.
of
you are
228,
43.
228 in both the letters. Lordship.
No,
Issue.
228 is for 7 numbers. Okay.
In both the letters, Lordship, the reference was 228. And the 228 letter was
okay.
for the status report of the 7 numbers who are working
Okay, okay.
regularly.
Okay, just a minute, just a minute. We'll have it. 228. 231. 231. But there is 231 of 43 numbers. You are in 231. That the separate letter is there.
231.
231. For
Asking for
43.
the status report of 43 numbers. That is
43
letter
numbers.
231.
And 228 has also been replied by 7 numbers.
Yes, yes.
231 has also been replied by the district. Where is the controversy started?
The date of engagement of the 231 letter, Lordship 43 numbers. The date of engagement of most of them are on second Saturdays in Sunday.
My lord,
And
they
most
were,
of the
that is a different
regular
matter.
master
engagement
brokers,
are
my lord.
underage, Lordship.
normally, my lord,
That-
they
that's
They
a
don't have a proof of no proof of engagement, Lordship, no. We have annexed the attendance register of the 7 numbers working regularly.
Let us read.
personal
let-
term
let us
pastoral
read the
laborers,
paragraph.
my lord,
And
they are
then
engaged
constitutional
normally on, my lord,
attendance and
holidays
Just a minute,
initiate.
pertaining to the essential level, 14 and 12 and 14 and 231. But 231 appears to have been issued. We thought that 231, whether 231 was there or not, 231 was there from the directorate. Pertains to 43.
231 is
231 is there.
That's the, my lord, only controversy, my lord, my lord, raised. First of it, and that 231 was never issued.
it's not 231.
Yes, what do you say?
What is the discrepancy regarding the letter dated 9/1/2018? The issue number was same. It was of 15/12/17 where the 7 letters of the 7 MR workers were called for.
Issue number was not the same.
But
Issue
now,
number was
Lordship,
48.
after perusing the records, no, the issue number of letter dated 9/1/18, Lordship,
Yes.
the reference number was same of letter dated 15/12/17. And that 15/12/17 letter was the status report of 7 number. That was the discrepancy. After perusing the record,
15?
this 9/1/18 letter is there, Lordship. Both the letters were issued on the same day. One was for 7 numbers of master roll workers and again for 43 numbers of master roll
Correct.
workers. And
So where was the controversy? 1512, which letter? 2812.
no, Lordship, the letter dated 9/1/18.
9118, there are two letters. We have
48
got
and
it.
49.
Yes, and the
The
other
49 letter, the reference was of the letter dated 15/12/17.
40,
In the 9/1/18 letter, that is issue number 49,
49, okay, 49. Okay, let us see. 49. 49, yes.
the reference is the letter dated 15/12/17, Lordship.
1512,
And the 15/12/17 letter
yes.
is the status report of 7 numbers of master roll workers.
No, 231. Oh, let us see. 231. No,
Lordship, 9/1/18, 2 letters were issued letter.
9118, two letters
letters
were
were
issued.
issued.
Even on 15/12/2017, 2 letters were issued. 1512, the director had issued 2 letters.
15/12, Lordship.
1512. One is number 28, 228,
228, yes,
which pertains to 7 numbers of
yes, yes.
master roll, and one is 231.
It is on 28/12.
Hmm?
231 is 28,
2812, you are right.
it is not 15.
This is the issue register of which
2008,
which office?
Dibrugarh, District Agricultural Office.
And this file, this record is of
This record is of the Director's Office and the District Agriculture Office.
Director's Office. You are not denying 2812, the letter of dated number 231. The
31 letter is
231 letter is that it's dated 28/12/2017.
28.
So the only discrepancy is of the date 1512 or
Yes, yes,
2812. That will not make any substantial difference because we find
Okay.
this letter here.
Okay.
Okay, we'll come back at 2 o'clock. We'll see for some moment.
Right.
Madam, there is one point which you are trying to project, that 2 letters from directors are there in the file. The letter which has been referred by the district is 231, but the date is 1512. 1512, there is no such letter, but there is a letter of 2812.
So the date is. the number is
Date has
there,
been misquoted, madam.
in both the letters, Lordship, they have given the status report.
And
reference of
the district has responded on 9th of January 18, it is possible. Even if you hold it to be not 15/12, but 28/12, 9th.
They
it's
couldn't
poss-
send both the letters
No,
together.
no,
Lordship,
both of,
43 and 7.
both letters have been,
That is
only
not
while,
one- in
while
one letter.
writing the number has not been, date has not been properly. We'll come back.
Lordship, in one issue number, in one letter, they could have given 43 plus 7, 50 numbers.
That is your director's letter. We cannot say
They
anything.
haven't sent two
Director has issued 2 letters, one for making a verification for
Yes,
7
yes.
numbers, one for 43 numbers.
Yes, sir.
They followed into 43 numbers.
seven
And
numbers.
that letter we have found in the file. Okay. Let's come back.
But I have a submission here regarding my lord item number 61. It may not reach today, my lord.
60.
60, your lord. May kindly be taken on Thursday, your lord.
Which matter?
Thursday on a hearing day, my lord.
60 is regarding what?
Regarding removal from service.
Okay. Matter of which year?
Matter, my lord, it relates to, my lord, 2017, your lord.
17.
Yeah.
কিমান আছে আমাৰ info matter? তাৰ আগত বহুত আছে, তাৰ ওপৰৰো আছে নেকি matter? No, admission play to. This 17 or. Okay, we'll have it on another day. Thursday করে দিই। Okay, Thursday.
All right.
Yes, you reconsider the case, their cases, okay? Because the entire premise of passing the earlier order
Yes.
was a doubt on the communication. Now the file records contain both the communications. Both are differently numbered. There is only one error in stating the date.
Okay.
That can be overlooked.
But the speaking order culminated from 2 inquiry reports,
Hmm.
which is annexed in the affidavit in opposition. But the petitioners at the time of engagement were also under it. They couldn't show any letter of engagement. Even from the 7 master roll workers, the records reveal that all of them have their attendance registered, they are attending regularly. The petitioners never attended our office.
Now you are making an averment of their underage, and they were
That is
working
the
since the
simple- That is in the
93, 96, they are working. And
is
if
the-
they were underage at that time, then can you deprive them of the regulation?
they were working in the farm sorting, which were
Now, you have
Later
taken,
he
you have,
saw-
your stand has to be consistent. For 7 persons, you have given the benefit.
some of
For 43 persons, you have given the benefit. Why 7 are left out?
no,
Seven they have given.
7 are
was
given the
speaking of
benefit.
seven-
Why
seven.
is 43 left out? Same process, same day.
They were there in the service lot, they attended the office, but this 43 workers never attended.
So where is
It
your,
is in the
you
inquiry
show us the
report,
material.
Page lordship part. The inquiries were done in 2 parts lordship, part A and part B.
Hmm,
That is page number 122.
of the affidavit,
Yes, lordship. Of the
One
first
two.
affidavit.
yes. 122.
That is part A lordship. That is the inquiry report party of appointment of 36 numbers of MR workers.
Hmm. Yes.
The 2 point C lordship.
Hmm.
The The two reports reveals the following 7 MR workers to be in continuous service till date.
Hmm.
They had been examined by the inquiry committee headed by the undersigned in 2 rounds.
Hmm.
So investigation has revealed that the matter has a prolonged history and that the government had ordered inquiries before the irregularities as doubted.
Hmm.
In the process, the above stated 7 workers whose existence has been proved beyond all reasonable doubt have become a victim of circumstance. The undersigned is of the opinion that the government be approached to provide budget and regularize their services so that they provide justice without. As regards the remaining workers, the inquiry committee has found that there is variation in the figures.
Hmm.
Right from the order passed by the erstwhile DO Dibrugarh, late 8 Hazarika to the recent appellant will comes to 40 numbers. As such, the undersigned feels the present DO should shoulder to the burden of entrusting duties to the person without any prior approval of the government. So this next lordship 124 page
Hmm.
list of the 7 MR workers who have been continually serving till today in the Dibrugarh district.
Okay.
A, B, C, D,
Hmm.
E, F, G.
Hmm.
These are the undertakings. Lordship, let him show one undertaking that he has got. Like this undertakings in page 126.
No, these are of the year 2015. They were
Very
directed
good.
to give a undertaking in 15. Whether the petitioners were directed and they have
So
not
they were
given.
regularly coming to service. Lordship, we never had. And when they were paid their salaries, the master roll workers has to sign the
Now, what
register,
is the
Lordship, and
problem
then-
in given undertaking? They will give hundreds of undertaking today. But
Lordship,
where they are asked to give an undertaking?
Never.
Lordship, they have to sign the master roll register and take
Yes.
the remuneration. They don't have, we do not have any record of them coming to office or
No, what are the meaning of these communications made by the director and the district office?
they are all hand in glove. That
Huh?
is the problem. That is the problem.
No, no,
There's
your
no
records have.
communication.
We are not on the
Yes, yes.
papers next to the writ petition.
Yes,
Your
yes.
records which you have produced, there are exchange of communications between the district office and the director. In the same manner, you have processed for 7. There is the same of the same date for 43. So how
Two
can you
separate
leave?
letters on the same day and
Same
then the
date.
lordship, the
You have not
second
said
letter is
anything
true.
that there is any doubt with these letters. Date is different. We still see that there is difference in the font, but
But the
letter,
reference that they are referring in both the letters, the letter dated 15/12/2017, lordship,
yes.
that 15/12 reference letter is of the status report of the 7 master roll workers who are regular.
No,
That is
1512,
the only discrepancy in the letter dated
1512 pertains to a letter number of not 231. 231 should have been dated 2812. That will not make any difference. Since we have a letter of 231 dated 2812 in your file.
And in the second inquiry report, lordship, that is on page 135, the comments and conclusions, part B of the inquiry report. Page
Yes.
1.
Is it against the petitioners? Is there any reference to the petition?
Late 8 Hazarika erstwhile DO Dibrugarh had placed 2 lists bearing same issue number,
Hmm.
stating total 64 MR workers who he claimed had been in service of the department with effect from 93 and in continue without break till 19 is the original and the root cause of this dedication. These 2 lists are adequate evidence that there is something fishy and doubtful regarding the matter. The present DO Dibrugarh has borne it as a legacy under 2 conditions as temptation of force or willful connivance that is an outcome of temptation. Bharat Das, the ex-serviceman of this department, has served in Margarita Sipsagar and who has claimed to be the guardian of 38 MR workers is well aware of the entire episode and that he may be asked to submit an affidavit. He is the only person to resolve the doubt. The inquiry committee felt that the evidence connected with the MR workers apart from 7 as submitted by part A of the inquiry report is not adequate as the figure 36, 38, 46 and 40 does not tally. The undersigned therefore feels that the matter of this remaining MR workers be placed before the higher authorities so as to provide a clear-cut reply to the writ petitioners. The inquiry into the appointment of 36 MR is hereby concluded. And then the speaking order.
No, these speaking order, impugned speaking order, which is the subject matter of this dated, what is the date?
16/8/2018.
16/8. 16/8. It is based upon the communication made by the directorate and the district office, where you had asked for, see what, let us see the contents of this letter, letter number 231 by the director.
Page 142, ma'am.
142. With reference to the subject cited above,
You see
28,
the letter is 2812,
28, 12,
whereas the now number is 231.
231, yes, sir.
Okay, 231, the only difference is that while referring this letter, 1512 has been written.
Yes,
Okay, now see which, what is the subject? Payment of master wages of master ruler so and so. With reference to the subject cited above, I am to state that as per the inquiry report submitted by the inquiry officer so and so, dated so and so, the following 43 master rule workers are working continuously.
They are funding, ma'am.
part A is not, but part A inquiry report is dated.
Let us see the inquiry report.
The part A.
1/12, 2017.
Part A inquiry report is dated 37, 2015. Page 122. Page 122, Lordship, Annex 3 of my deputy note.
122.
Page 122, Lordship, this is the part A inquiry. Date is 37, 2015.
Part A. Where is part A? Inquiry report.
Subject, inquiry report, party of appointment of 36 number master roll worker. Date is 37, 2000. Page 122.
There are subsequent reports also. I connect to reports by the committee. They have constituted a committee after that report was submitted by the inquiry officer. Page 78.
Madam, your original file contains this 28/12/2017.
Yes, 231 letter is there.
No, no, 231. What is the contents of this letter, madam?
Status report of the 43 number.
Why,
of
why
master roll.
43? If you are referring to an inquiry report of 1/12/2017, have you seen what is 1/12/2017? Is 1/12/2017
That letter is here.
is in the writ petition? 1/12/2017. Is it in the writ petition?
112, no,
Have you annexed 112 anywhere?
No, my God, 112 is not there.
After 112, how could you have written this letter? You see what is 112? Very surprising. Yes, have this file. See the yellow flag here. Madam Bora,
yes, sir.
you have 112.
No, no, no.
You have one to see 112. Read the entire letter. Read the entire letter, not the first page. First see that 231, the reference. First see 231 reference.
230.
See the reference, see what has been stated. Pursuant to Khoghan Gogoi's letter number what?
231 letter, Lordship.
231, what is the reference to the inquiry report?
With reference to sub yes, is 11217 letter.
Oh, see the number also, number by whom?
Number, yeah.
Same letter?
ADA ER3.
See the last
Okay,
number.
yes.
You don't need
Yes,
to
yes,
read.
97.
97. Okay, read this letter now.
Placement of the master roll 50 appointed under District Agricultural Officer, Dibrugarh, reference number. So, with reference to the subject matter stated above, I have the honor to place my observation and submission as follows. The following MR workers 7 numbers have been placed as so and so.
And
7.
then line, they are still. Then next line, they are still continuously what?
7 are continuing.
Yes, what is the line?
The
Please.
above mentioned workers are still serving the department, though without any remuneration.
Yes, next page. Come to the next page now.
The remaining 43.
Yes, please read the
workers,
entire line.
Yes, were placed in various offices of the district, like PO offices, farms, which are no longer in existence.
They are
They
not
have-
working. 43 are not working. So how could the director again say in a mechanical manner?
43 are not working. That
Then
is
how into a page 231, the reference has been made, they are in continuous working. Where is
That
the
is not
word?
also- that is the problem.
No, a director's letter is a part of your records. That's not a,
The then director.
whoever,
Yes, yes.
just see the contents of the letter of 231. Please read.
With reference to the subject cited above, I am to state as per inquiry report submitted by inquiry officer, Shri Kalparanjan Gogoi, letter dated so and so, dated 1/12/17, the following 43 numbers of master roll workers are working continuously till the
Where do you get the basis?
That-
Kalparanjan Gogoi says 43 are not working.
the remaining 43 workers were placed in various offices. They have to
The other
not receiving
findings of the inquiry officer are in connection with the 7 numbers found to be working. Mr. Saikia, there is a problem.
First we'll finally turn to page 70 of my.
And problem we thought it was in the bottom, problem is on the top.
I have no access to that, but the
Problem is on the
subsequent
top.
inquiry reports by the same inquiry officer.
If a fish rots, what rots first? This is the head.
The same inquiry officer,
Unfortunately, it's the head which has rotten.
the same inquiry officer says that they were working.
No, he has not said.
Yes, subsequent reports I have annexed in the repetition method.
Please
That
let us see.
report- That report is of 2016.
Let us
This is
see.
the last one, 2017 is the last.
Let us see the report. No, whatever you may say,
Right.
your basis of this claim is a recommendation by the director saying that you are in continuous service.
Yes.
That recommendation is based on an inquiry report by one Kalpo Gogoi.
Kalpo.
Kalpo Gogoi says the 7 are working, 43 are not working.
Same
Director takes a perverse view,
my lord,
a
the
wholly
same-
contrary view.
Same Kolpo Gogoi, my lord. He has sent,
When?
my lord, to be kindly turn to page 78. It is
Which date?
6/9/2016.
So this is 17,
Subsequent
page.
page 78, my lord.
Let us see what is 78. Yes. Please read.
My lord. Re-examination of matter connected with the regularization of the services of 42 numbers of master workers appointed under the Dibrugarh district. The history of the matter has been, my lord, cited in page 79.
Yes,
My lord, thereafter, the findings supposed to be kindly turn to page 80.
yes.
Expelled number of petitioners is 44, and the state will have to regularize these workers if the government wishes to be fair to these victims.
Yes.
These petitioners had been misguided, victimized by some mischievous officials of this department. They had been lured of regular posts in the department by these persons as expressed in hearing. That these people have been anxiously waiting for regularization area wages provided that they had
been deceived by this person. These petitioners may thus be considered to be victim of deception. As such, the government will have to decide as to how these 54 master workers found to be appointed by the Arsenal Dow and continuation of this department by the next Dow, who had also placed budget demand be made, providing true and fair justice.
This re-examination was pursuant to what by this committee?
My lord, it is by page 81.
But this
So,
communication,
68.
which is in the file, these are of subsequent dates.
Yes,
This have become
thereafter, my lord, the state Kalpuranjan Gogoi wrote a letter to the director, my lord, page 91. Page 91, my lord.
Yes.
What was this finding in this report, my lord?
Hmm.
With reference to the subject cited above, mentioned above, I have the honor to place my observation and comments as follows. During my term as ADA, I had been entrusted by the actual director, Dr. Govindra Barkatoki, to inquire into the status of master workers appointed by the Arsenal Dow, Dibru, late Hemanto Hazarika. During the first round of inquiry, I had found out the following 7 workers who were placed as follows. 7 master
Hmm.
workers.
Hmm.
The inquiry was made as per the petitions filed at Guwahati High Court. It was also revealed during the inquiry that Arsenal Dow Dibrugarh so-and-so, who had been nominated as presenting officer, could not provide sufficient documents and had claimed that most of the documents had been missing and damaged due to time entering rainwater in the office as well as shifting to the newly constructed building. First round of inquiry was completed and report sent to the director requesting him to time for further proof into the matter. Re-examination of the matter had been done on so-and-so, with K. Lahon Arsenal Dow, Hebrew as matter member secretary and S. Gogoi, the lead and assistant director and present Dow Hebrew as nodal officer. The Arsenal Dow late Hemanto Hazarika had appointed 27 plus 37 64 MR workers and themselves had been placed before the administrative officer directorate of agriculture Assam by 2 letters number so which above mentioned numbers. The present number comes to 7 plus 43 is 50. My observation as inquiry officer is that
Mr. Saikia, this letter is written by a retired employee.
Yes.
After his retirement, in his
Yes.
personal capacity.
He has clarified the
In his
inquiry.
personal capacity.
Yes.
See the original, the handwritten portion.
Yes, fine.
He's not even an employee. Where does he get the authority? And he marks the letter to the union leader. What is this going on? Page 94, copy Hemanto Gogoi, group leader of masteral workers.
My lord.
Where is the occasion to write this letter?
My lord, he has clarified the my lord,
No, why?
position.
Will you go by this letter? By retired personnel without any authority? Was his views sought for?
I am just placing this letter, my
What
lord,
was his views sought for?
to substantiate that my lord, the inquiry re-examination of page 78.
Was his views sought for?
Page 78 has been clarified by him.
Where is the occasion to clarify?
That
Who asked?
but page 78, my lord, it says
We have seen 78. In
Yes.
context of 78 only you are asking.
time and again,
Yes.
even my lord, I have got that my lord, attendance register also, xerox copies of his attendance register, wherein my lord, the petitioners were my lord, working and they were signing the attendance register. Let there be a fresh verification, my lord, on
This
director
is of
level.
9/4/2018. You have that verification done. Director writes something in spite of a clear inquiry report.
My lord, inquiry report, my lord, does not say that they are not working.
It has said
But
for
record-
7 they are continuously working. For 43 they are no longer in existence.
my lord, their records were not found.
No,
Due
that
to-
is not the. Unfortunately, that is not the finding which you have enclosed here. The finding is different.
Fine.
Here we have seen
Yes.
that due to shifting of the office,
Yes, yes.
water entering, that's a
Yes.
different matter. There the inquiry is different, report is different.
It is done letter. Let there be a fresh inquiry. Well, these petitioners, they are without salary since 2004. Since 2004. If they are working, they should be paid. My case is that, my lord, if they are working, they should be paid. If they are not working, my lord, they should.
You are not working, there are materials on record that you are not working.
But my lord, only that in.
Where are you working? Where are you working?
In my lord, the block office,
Where?
my lord.
Where?
Block office, my lord. I have got the attendance register.
No, no, where have you stated? Where are you working? Block offices.
In different block offices.
Where, where?
Here is the attendance register
No,
of my lord,
forget the attendance register.
King Bhong Rajgor.
Where are you working?
It was certified by the agriculture development
No,
officer.
no, where is your statement in the writ petition? Which paragraph?
Paragraph. Paragraph 2 is the engagement, my lord. Paragraph 4 is the, my lord, after 4 and 5.
Yes. Please read.
Paragraph 4, I am reading, my lord. So the
Yes.
petition is to state that by two separate orders, stated so and so, that Dow Dibrugarh placed posted
That
some
this
of the
is not on
petition-
continuous work. Where have you stated?
Yes, my lord. Last line, my lord. On the
Yes.
other hand, all the petitioners are working continuously under the respondent authority.
When, where?
My lord,
Paragraph?
Paragraph 4, my lord.
4.
Yes, ma'am.
Let us see how we verified. Paragraph 4.
My lord. My paragraphs are missing, my lord.
Not missing.
Well,
We have paragraphs here. You have verified as true to the records. You going to the office daily on continuous basis, it's true to the record.
because I think the states are.
You don't verify your action, which you have done from a register. You are going to the office, you are working. It's a matter of knowledge,
Yes.
personal knowledge. Register can even say something else. You have not verified.
Attendance register, my lord, what I have seen, my lord. There, my lord, their petitioners are, my lord, regularly attending, and the agriculture officers, my lord, they have endorsed that matter.
This matter was on a Harshri ISCK learned consent for the petitioners, whereas the Department of Agriculture is represented by Miss R. Boda. Mr. Nayak, you are also appearing.
Yes.
So Sri P. Nayak appears for the Finance Department, full stop. This matter was considered at length on the last occasion, that is 25/4/2024, when the following order was passed. Full stop. In accordance with the aforesaid direction, comma, the records in original of the office of the directorate, as well as the issuing register of issue register of the Dibrugarh district office have been produced, full stop, para. So far as the controversy regarding the aforesaid two letters mentioned in paragraph 7 of the earlier order is concerned, comma, this court has noticed that apart from apart from the mention of a date by the let us have a look at the direct record by the district office, comma, it appears that separate letters were issued by the directorate with regard to 7 numbers and 43 numbers of master roll workers. Full stop.
My lord.
Yes. While the letter pertaining to 7 numbers of master roll worker is number AGRI stroke ESTT stroke 8105 stroke 2014-15 stroke 228 dated 15/12/2015, comma, the one pertaining to 43 master roll workers is number গোটেইখিনি একে লাষ্টৰখিনি 228 জায়গা 231 হ'ব dated 28/12/2017. Full stop. It is the second letter wherein the date has been wrongly written as 15/12/2017 in the communication made by the district agriculture officer dated 9/1/2018. Full stop. Para. The controversy, however, would not end with that. Full stop. This court has verified from the record that a communication number JDA within bracket ER dash Roman 2 bracket close oblique TSK oblique ESSTT dash C capital C oblique MR oblique 2017 oblique 97 dated 1/12/2017 was made by the Joint Director of Agriculture, comma, Tinsukia, on the subject of 50 numbers of master roll worker. Full stop. In the said communication made to the director, comma, a clear distinction was made between 7 numbers of master roll workers who were stated to be serving the department, though without any remuneration, and the remaining 43 were placed in various offices of the district like BAO offices, firms which are no longer in existence. Full stop. It appears that without taking into aspect the without properly taking into consideration the findings given in the said communication dated 1/12/2017, the Director of Agriculture had issued 2 letters one for 7 numbers of masteral workers who were stated to be working, and the other for 43 numbers of masteral workers, within bracket the petitioners, who were stated to be not working. Full stop. Para 3 Saikia, the learned counsel for the petitioners on a specific query regarding their continuous service has referred to the averments made in paragraph four of the writ petition, more specifically, the last sentence, which reads as follows. Page 16, paragraph 4, last sentence. On the other hand, this court has, however, examined as to how the said averment has been verified in the affidavit, which has found to be verified as being true to the information derived from the records. Full stop. Para. Our writ proceedings, unlike a civil proceeding, does not have the procedure for reducing evidence and cross-examination, and therefore the affidavit accompanying the writ petition attains paramount importance. Full stop. This court is of the opinion that a communication wrongly issued by one of the authorities, which is clearly contrary to the basis of the same, will not bestow any right to the petitioners to claim the benefit of regularization of service. Full stop. This court is therefore of the opinion that the impugned order, that the petitioners have failed to make out any grounds for interfering with the impugned order dated 16/8/2018 passed by the director, whereby the claim of the petitioners for payment of their wages has been rejected, full stop. As there is nothing on record to suggest that the petitioners were rendering their service, comma, the aforesaid claim appears to have been rightly rejected, full stop. Writ petition accordingly stands dismissed. The records are handed over back to the Learned Standing Council. এটা লাইন লিখিব লাগিব। Sri Saikia, the Learned Council has tried to rely upon a communication dated so and so. Full stop. The said communication, however, has been found to be issued by one so and so after his retirement, and there was no occasion for issuing the same. We did to query, to open a query. Yes.
Lordship, matter relates to removal from service of an SBI employee, Lordship, while he was serving as assistant manager accounts Koupati branch. Now, Lordship, he has expired during the pendency of this particular writ petition, and we have substituted his legal hire.
Okay.
Now, this is the second round of litigation. In
Yes.
the first round of litigation, Lordship, the respondents fairly admitted violation of many procedural irregularities, and on the basis of that, Lordship,
Violation of many procedural irregularities.
in the disciplinary proceeding, Lordship,
Violation of many procedural irregularities.
Yes. Non-compliance of many procedural aspects, Lordship, under the rule.
Okay.
Existence of many procedural irregularities
Okay.
that was admitted,
Hmm.
considered, and ultimately, Lordship, the inquiry report, penalty order, and the appellate orders were set aside with direction to conduct de novo inquiry.
Okay.
In the de novo,
That was in the earlier round.
in the earlier round,
Okay. Thereafter,
Pursuant to that, Lordship, de novo inquiry was conducted with a different set of inquiry officer and presenting officer. And ultimately, Lordship, here also they committed the same irregularities and illegalities, even much more than that, Lordship. I would like to place one by one, Lordship. First, Lordship, the disciplinary authority, what he did, Lordship, he accepted and agreed the findings of the inquiry report against each of the article of charge even before furnishing the inquiry report to the delinquent, to the employee. That your Lordship will find that
tell us the facts.
yes, facts, Lordship, the charge sheet, your Lordship will find at page 28.
The petitioner was what? The
Petitioner was working as assistant manager accounts. Assistant manager accounts at Koupati branch.
Koupati.
Koupati.
Which district? Which district? District. Okay, doesn't matter.
I will
Okay.
inform. Then, Lordship, charge sheet has page 28.
No, then you are placed under suspension. No.
Yes.
When?
He was
When did the original petitioner pass away?
passed away. Uh, 5/11/23.
5/11/23 petition. Legal errors substituted.
Substituted, wife and son.
Mr. Boga, have your seat?
Yes.
Yes, when were we suspended?
Suspended 30/5/2012.
30?
5/2012.
Yes, suspended.
Suspended. Thereafter, charge sheet.
Which is the page of suspension?
Suspension order, it is reflected in the first round of litigation order itself, page 38. Lordship will find.
38. Okay, doesn't matter.
Then charge sheet,
Show cause, where? Page
page 28.
28.
Lordship, co-party is Dorong district.
Okay.
Now charge sheet at page 28.
Yes.
Allegation is little-
1412.
14/12, 2012.
Show cause notice. Okay.
Allegation at page 29.
Hmm.
I'm reading it out.
We'll just
Yes,
have a
allegation is basically, Lordship, it is a little peculiar. His allegation is that he has debited many accounts, and he has credited those money from those accounts to his own accounts and several other accounts, various other accounts. That is the allegation, Lord. Allegation prima facie is that, Lord.
25 lakhs.
25 lakhs. 25 lakhs probable loss. All throughout they say probable loss, but ultimately in the penalty order, without any evidence, without any finding. it
Okay, then
becomes-
what happened?
Yes. Then, Lordship,
You filed your reply.
I filed my reply. Page 39. It is reflected, Lordship, in the first round of litigation, Lordship.
39
Petitioner submitted short reply, page para 7, 28/1/2013.
you have not annexed here. Okay. 39.
The,
You replied.
I
Then
replied. Then inquiry report.
where?
Lordship,
Annexed.
Lordship, the incident prior to the first round of litigation documents I have not enclosed because it is
Okay.
reflected in
Okay.
the
Inquiry report. Is there any date?
date, Lordship. It is 17/5/2013. Page in the order it is reflected.
Okay. So inquiry report.
Inquiry report. There was
Held the charges to be proved.
held charges to be proved.
Uh,
Then I replied against the inquiry report.
It was given to you.
It was given to me
Okay.
by already agreeing with the charges by that.
Where?
That your Lordship will find that page 39, para 10. Para 10. First round of litigation, para 10. Copy of the inquiry report was furnished to the petitioner by the disciplinary authority via his forwarding letter dated 18/5/13, informing the petitioner that he may submit his written statement on the inquiry.
Okay. We have read.
Yes.
Then you
I replied.
replied.
36/2013.
36, 13. Okay.
Then penalty, they gave me a personal hearing also, but that
Okay.
is inconsequential. Then penalty order,
Dated
24/9/2013.
penalty.
24
What penalty?
removal from service.
Removal.
Removal.
Okay.
Then dismissal from service and forfeiture of gratuity.
Dismissal, not removal.
Dismissal from service and forfeiture of gratuity.
Yes.
Against penalty order, I submitted appeal.
Okay.
Appeal dated 30/11/2013.
Yes.
Then the appellate order was passed. Penalty was upheld. Appellate order 17/2/2014.
Appeal dismissed.
Appeal dismissed.
Appeal rejected. Okay.
Rejected.
Okay.
Then I approached this honorable court.
In the first round.
First round. Page
WPC
WPC 3941/2014.
3941 14.
14.
Okay. Allowed.
WPC was
Allowed.
allowed. Disposed of, Lordship. Disposed of operative portion, page 41.
It is
The
dated
report of the
4/8/15.
yes. 4/8/15.
What was the operative part?
Para 21.
2-1.
21, page 41.
Yes.
A report of the inquiry officer dated so and so, penalty order dated so and so, and order of the appellate authority dated so and so are hereby set aside and quashed. Departmental inquiry against the petitioner on the same set of charges shall be conducted de novo. Petitioner shall be deemed to be under suspension since 35/2012 all throughout and shall be paid his due subsistence allowance, both arrear and current, within 2 months.
Temporary suspension. Okay. Do you know? Yes.
Lordship, first round of litigation, may I read para 16, Lord?
Why? Not required.
That they considered the
Okay.
irregular.
Okay. 16.
16. Today, page 40.
Hmm. Hmm.
Today, when Mr. Sharma rose to argue on behalf of the bank, while deprecating the conduct of the petitioner, he, however, fairly considered that the departmental inquiry conducted by the inquiry authority was not in accordance with law, inasmuch as there was no discussion on the evidence adduced by the witnesses in the inquiry.
Okay, okay, doesn't matter. Okay.
Yes.
It is otherwise even set aside by the court.
Yes. Then, Lordship, new IO and PO were appointed.
Hmm.
And the inquiry report was issued by the inquiring authority to the disciplinary authority
When?
on 24/12/2020, page 56.
'56, yes.
Page 56. Enclosed therewith is the inquiry report. Now, in the inquiry report, at many places, your Lordship will find the disciplinary authority has immediately after receiving the inquiry report, after going through, he has agreed with the findings of the inquiry report without even furnishing the copy of the same to the delinquent for his reply. First, Lordship will kindly see page 63. Page 63. He has written it by his hand, but a typed portion is also there, Lordship. Page 63, horizontal pages,
Yes.
the inquiry report. In the right side column, he writes, I agree with the view of the IA. Date is 31/12/2015. This is the date when the inquiry report was furnished to me. 31/12, he agrees with it and then furnishes to me. 31/12/2015. This is regarding article of third number 1. Then page 97. Page 97.
Yes.
97 also. 97 also he writes, I agree with the view of the IA. Date is 31/12/2015. Similarly, page 104, 106 and 108. 104 is very legible. 104, I agree with the view of the IA. 104, last column. Regarding all the charges, findings in respect of all the article of charges, he writes like, I agree with the view of the IA. Then page 106, he again writes, I agree with the view of the IA.
Okay.
Then Lordship will kindly come to page 110. This is the letter by which the inquiry report was communicated to me.
Okay.
With reference to the letter dated so and so, I forward here with a copy of the inquiry report. With inquiry report come findings submitted by the IA. Now, Lordship will see disciplinary authorities comments. He writes, I agree with the view of the IA. Allegation is proved. After that, he forwards it to the delinquent. Now, now what they say in their affidavit opposition regarding this thing, Lordship. Affidavit in opposition, Lordship will kindly come to page 13.
13. Yes.
Para number 19. Para number 19, third line. He says, I say that before doing so,
Page 13.
page 30, running page 132.
No, no, internal paragraph
Internal paragraph, page 19, para 19.
19.
19. He writes,
Just a
Lordship,
minute, please. 132. Yes, please. Please read.
Yes, Lordship, third line, para 19, I'm reading.
Mm.
I say that before doing so, disciplinary authority, a responsible officer had duly considered the report based on the available records and having agreed to the findings recorded therein, forwarded the report to CSO, giving him reasonable opportunity to submit his written statement of defense. Then again, Lordship will see para page 6. Page 6. Page 6 also same kind of statement, Lordship. He writes.
Page 6.
Page 6 also. Same thing he has written.
Page
that
6 paragraph.
Paragraph 8. 8, Lordship. Paragraph 8. From top, Lordship. Fourth line, Lordship will say, Honorable Supreme Court has observed that the judgment cited by the employee has no such proposition that even before tentative conclusion is arrived at by the disciplinary authority, inquiry report has to be served upon the employee. He says like that. Now, Lordship, what they
What is the judgment? This thing? Bolaram Bodola?
They have relied on this judgment. They say that second stage, second scope for giving reply against the proposition to punishment, that is not necessary. But that does not mean that that they will.
No, this
Bolaram.
This one at page 6.
Yes.
Wherein, while upholding the decision of this court, the Honorable Supreme Court observed that the judgment cited by the employee has no such proposition that even before so and so has to be served. Okay.
Lordship is stating about Bolaram.
Yes, Bolaram, they have decided.
They have relied. We had relied upon Managing Director ECIL versus Karunakar. Lordship will kindly have a copy of that judgment, para 20.
No, Karunakar is okay, but what is anything to the contrary of Karunakar stated in Bolaram?
No, Lordship. Bolaram is a High Court judgment.
No, Supreme Court has.
Supreme Court judgment, yes, I'm sorry, Lordship. Bolaram is a Supreme Court judgment, and it is not in respect of that aspect, Lordship. Bolaram says that, Lordship, that before coming to a finding by the disciplinary authority regarding the penalty to be proposed, regarding that proposal, he need not give me an opportunity.
That is the 42nd Amendment.
Yes. That, regarding that, Lord.
Okay.
So second stage is not.
That has been explained in Ramzan Khan. Have you got Ramzan Khan?
Lordship, this ECIL is
Before in the ACL 727, Ramzan Khan 1990. Did you get the decision? That is exactly on 42nd Amendment. What is the purpose?
Yes. But that
ECIL has only explained Ramzan Khan.
Yes.
The main case is Ramzan Khan.
Main case is Ramzan Khan, but
ECIL has said it will be prospective from, what is the date? November 1990. What November? 11 November, I think, or 29 November.
1/11/93.
No, not this. The Ramzan Khan judgment. It's explained in ECIL. You see,
yes.
It will be prospective.
Yes.
CD had not, I think 1/11, 29 November 1990. Or 10 November. Okay, doesn't matter.
The citation is 91 ST 471.
Give me that.
One para, Lordship, I am relying on.
Give me that. ACL, no need to rely. Give me that ACL.
One para 20, Lordship, may kindly speak up. Para 20.
Just a minute, just a minute. Uh, 2011, 20th of November, 1990.
Your lordship query is at page 20, para 23.
Which one?
That second says for 44th amendment,
42nd.
42nd.
Para?
Para 23. Section 44 of the 42nd Amendment done. Amendment Act done away with supply of the copy of the report of the proposed punishment, but was not intended to deny fair, just and reasonable opportunity to the defendant.
Yes.
Lordship may kindly have a look.
No, no, what is, no, these are okay, this we can, now what is your case?
Case lordship, one para may I read lordship, this ex post facto opportunity does not efface the past impression formed by the disciplinary.
That is not required, these are all settled principles.
Settled
don't-
law. Lordship, now this is one of the ground lordship, that he already made up his mind regarding the findings of the inquiry authority, then given me scope to submit my reply. So that does not efface his mindset, lordship.
Hmm.
Then lordship, another ground lordship, in the charge sheet, the amount has been mentioned as a probability,
Hmm.
page 29.
Yes, we have seen that.
In the as a probability, but lordship, in the penalty order, without any findings in the inquiry report regarding the amount, they have come to a solution that it is no more a probability in the penalty order and also in the appellate order, and these amounts are different, but there is no finding how they have arrived at that amount. And lordship, then another lordship, my ground is that lordship, in the charge sheet, no witness is mentioned. Although there are many documents, lordship, list of documents, but there is no witness. They are not sure how they are going to prove these documents by way of any live evidence. So there is no witnesses. So no witnesses
In
were
in the inquiry,
yes.
no inquiry, no witnesses
No
were,
witnesses were examined. But beyond the charge sheet, they have written the name of one Uttam Kolita. One Uttam Kolita has been, the name is mentioned in the inquiry report that I can show lordship, but lordship, he has not been examined nor cross-examined. And moreover, lordship, the allegation was very serious. Amount was deducted from some accounts and it was credited in some other accounts, my accounts and several other accounts. But none of the beneficiary, no.
okay. What is your submission on the deduction of gratuity?
Gratuity, lordship, if penalty order is gone, then lordship, I'll get the gratuity also.
No, no. You have to make a specific, see, there are two parts. One is removal and one is denial of gratuity amount.
Yes.
Gratuity, what is your take? What is your submission?
My submission is that lordship, right from inquiry report, penalty order, appellate order, everything are rehearsed the rules and settled position of law. So if everything is
No,
set aside,
forfeiture of gratuity may not be in the realm of the disciplinary proceeding. Forfeiture of gratuity has to be a separate proceeding. You have not argued anything. What is the Gratuity Act?
gratuity,
Mr. Sharma, you should come prepared to the Gratuity Act. How can you forfeit gratuity? Can gratuity be forfeited? And if yes, what is the condition?
My humble submission is that Lordship, gratuity is part of the pension, Lord.
Pension is different, gratuity is different. Gratuity is by this Payment of Gratuity Act. You have a look. I think section 4. Can gratuity be forfeited? And if yes, under what condition?
Payment of gratuity. Gratuity shall be payable to an employee on the termination of his employment after he has rendered continuous service for not less than 5 years.
It has got nothing to do with pension. The gratuity is a different aspect. Then
On his superannuation or on his retirement or resignation or on his death or disablement due to accident or disease.
yes. Then
Provided that the completion of continuous service of 5 years shall not be necessary where the termination of the employment of an employee is due to death or disablement.
and when gratuity can be forfeited?
Provided further that in the case of death of the employee, gratuity payable to him shall be paid to his nominee.
Next.
Explanation: for the purpose of this section, disablement means
Next.
For every completed year of service or
Next.
part. Provided that in the case of a peace-rated employee
Next.
daily. Provided further that in the case of an employee who is employed in a seasonal establishment,
Not this. Next. What? Regarding forfeiture.
the amount of gratuity payable to an employee shall not exceed. For the purpose of computing the gratuity payable to an employee who is employed after his disablement, or
Then
nothing in this section shall affect the right of an employee to receive better terms of gratuity under any award of
Then-
or agreement. Power to exempt.
not power to exempt. Give it to us. Give it to us. You have to make an inquiry and you have to ascertain how much loss has been caused to the organization. That is the only way where you can forfeit gratuity. You cannot otherwise. You have read everything. You have not. You are not reading the subsection 6. You are reading section 4. It's in section 4 itself. Sananda. Read subsection 6 carefully and slowly.
Notwithstanding anything contained in subsection 1, the gratuity of an employee whose service has been terminated for any act, willful omission, or negligence causing any damage or loss to or destruction of property belonging to the employer shall be forfeited to the extent of the damage or loss to cause. The gratuity payable to an employee may be wholly or partially forfeited if the service of such employee has been terminated for his riotous or disorderly conduct or any other act of violence on his part. If the service of such employee have been terminated for any act which constitutes an offense involving moral turpitude, provided that such offense is committed by him in the course of his employment.
So first, in the first,
First
the one which will be applicable is the first one.
First one.
And what is the requirement? That it has to be ascertained how much loss has been caused by you.
Yes.
And in a vague statement, the probable loss will not do. You cannot forfeit. And the subsection starts with a non-obstante clause, notwithstanding anything. You
Yes.
cannot forfeit, only under circumstances. So that part, they have not done anything.
Not-
And even if in the worst case, we uphold the removal order, you still get the gratuity. But you are making a case that even the removal order is not preceded by the procedure established in law. Yes, Mr. Burgoyne.
First, the main case the petitioner has made out is that there's procedural lapse, Your Lordship. Procedural lapse is there
In the inquiry.
in the inquiry.
Yes.
For that, Your Lordship, on the last occasion, I have prayed before this honorable court to bring on the record
Yes.
of the anti-disciplinary proceeding. Here in the record, Your Lordship, the court is
No, are you disputing that he has taken this court to that bunch of findings where he had made some handwritten notes or concurrence or whatever? For even if you ignore with those notes, if you come to the second show cause notice at 110, 110.
Lordship,
110, the disciplinary authorities comments, he gives comments.
Lordship,
That allegation is proved, allegation is proved, allegation is proved, allegation is partly proved, allegation is proved.
Lord.
Now, he has come to a conclusion, allegations are proved. Then will the formality of giving him an opportunity, so-called opportunity to make his submission on the findings of the inquiry report, will it make any meaning? Number one. Number two, he has gone one step further that even in the inquiry, no witnesses were produced. So, see, in an inquiry, normal parlance, the disciplinary authority can himself do the inquiry or he can delegate to an inquiry officer. And these are allegations which are mainly based on documents. So, documents, the proof by means of documents will not mean that the documents are not required to be proved. We need not follow the strict rules of evidence, but principal justice, yes, and minimum semblance of adherence to the Evidence Act has to be there. How would you prove a document?
regarding the,
Was there any witness who had
there was
presented?
a witness, your Lordship.
Did he
The-
do anything?
The
Uttam.
record reflects, your Lordship, that
Yes.
there was witness and ample opportunity was given to the petitioner.
No, not to the petitioner. First, did you discharge your duty properly? We are not on his
We
role.
have examined the witness.
Did you?
Yes,
He had statements recorded.
statements were recorded, your Lordship. It's
In-
there in the record.
That Uttam Kolita.
Some of the-
Is it of Korean, right? And that is the second aspect. The first aspect,
the
how
first
do you
aspect regarding the
how
making
how
up
do you ensure that the principle of natural justice, as explained in Ramjan Khan and MDCIL elaborately,
Not-
that 42nd Amendment has taken away the requirement of giving the proposed penalty, but that will not mean that he will be deprived of an opportunity to convince the disciplinary authority to take a view which are views against him by the inquiry officer. Or if the inquiry officer is a different person. If it is the disciplinary authority, then there is no such requirement.
regarding the comments made by the Lordship, the departmental inquiry, the disciplinary authority.
Right.
These comments are just as same as like taking cognizance, your Lord. Initially, if the disciplinary authority has been
See,
satisfied.
we go by records.
Lordship,
What was in his mind, we do not know. He has not even used by use of terms like tentative finding or that might have some bearing. But he comes, allegation is proved.
And thereafter, he was given the opportunity.
And that too, this is the second round of litigation.
Okay.
First round you have considered. What Mr. Sharma has pointed out from the judgment, that paragraph 16, I think. What was the paragraph?
Paragraph 16.
16, I think. 16 was a concession made by you. And
have-
rightly, fair
We have
concession.
considered to. that
That's a
your
fair
Lordship,
concession.
Lordship.
As a officer of the court, you have to concede. No, you are committing the same mistake. And the person has expired in 2023. We are not for a moment endorsing or even approving that bank officer. The nature of allegation is very serious. And bank officer, so Honorable Supreme Court has time and again said that he works in fiduciary capacity.
Integrity.
The integrity should be much higher than a normal government servant. He's dealing with public money. You had a good case. You are not following the rules of procedure. You said an inquiry, one witness has been produced and examined. Let us see that
The
part.
records are.
Kindly check.
If I may request, your Lordship, the matter can be taken up on witness day. In the meantime, I will prepare the documents.
No, no,
for the
what
committee.
documents? We have heard, we have finished the hearing. Now, even if you make out a case, the witnesses were examined. How do you overcome this?
The
There's
comments,
a second so-called 110. 31/12/2015. And now the worst part is that if we remand it back, who will now say
He's not alive.
he's not alive? How can there can be an effective reply to the findings of the inquiry officer? What was your age? No, not your age,
Yes,
age of the
yes.
original petitioner. Now the wife and son is there.
My wife and son.
What was the age of the original petitioner? At the time of filing?
Filing writ petition 42, Lord.
At the time of filing 56. Huh? House number 42, age 53.
53, Lord. 50.
And if you have committed the same mistake twice, you should have advised them properly. This is not how you do.
There are other procedural irregularities also. There was a CBO finding. That CBO's finding was also not furnished.
What was CBO's finding?
That was not furnished only. The penalty order was based on the CBO's finding. There was judgment to that effect also. Anything relied by the disciplinary authority penalized, that should be furnished.
Regarding the inquiry part, Lordship, he has admitted that he is satisfied with the inquiry. But the comments made thereafter by the disciplinary authority, that is critical.
Even he cannot say I'm satisfied with the procedure in the inquiry. He should leave everything to the delinquent. Make your views. This
No,
is
the
the inquiry.
delinquent officer, he has himself admitted that he is satisfied with the
Oh,
inquiry.
delinquent has said. Where?
But the comments that made thereafter, Your Lordship, by the disciplinary authority, that is critical. In the very first line,
Hearing is concluded. You want to begin. But
even he was asked whether he wants to give any evidence.
no, inquiry proceedings he may say that I am satisfied. That will not obliterate the or do away with the requirement. The huge public money is involved. You should have been very careful.
Actually, Lordship, there was no complaint from any corner.
No, not you. I am asking you. You should have been careful. These are very important matters. Okay, no way out. Item number. You are Dr. G.J. Sharma?
Yes.
Heard Dr. G.J. Sharma, learned counsel for the petitioners, whereas the respondent SBI, State Bank of India, is represented by Sri H. Borgohai. Buragohai. Full stop. The challenge in this writ petition is towards a disciplinary proceeding initiated by a charge sheet dated 14/12/2012, comma, the inquiry report dated 24/12/2015, comma, penalty order of dismissal of service and forfeiture of gratuity dated 24. Why is it 24/9?
So penalty order 16/5/16.
16/5/2016.
This is removal. Removal
Which was removal?
penalty.
It's a dismissal with forfeiture.
Lordship, first time it was dismissed.
The first time.
Second
Okay,
time.
Okay. Penalty order of removal from service with forfeiture
Forfeiture.
of gratuity dated 16/5/16 and the rejection of the appeal by the order dated 2/12/2016. Full stop. The challenge is structured both on the merits of the allegation as well as gross procedural irregularities and infirmities. Full stop. Para. Before proceeding, comma, this court has been informed that the original petitioner, delinquent, had expired on 5/11/2023 and he has been substituted by his legal heirs, namely, who are these legal heirs?
Wife Srimati Olympia Roy and son Onindit Roy.
Why there are two petitioners initially?
Initially, Lordship, the son, he was minor, he was also made a writ petitioner.
Why?
The ground I took that, Lordship, his studies were affected because father's income was short. Ultimately, Lordship, father died and
Original petition number 1, delinquent Anirban Roy had passed away on 5/11/2023 during the pendency of this writ petition, and he was duly substituted by the present petitioners, who are his wife and son. Full stop. Para. The present case has a checkered history, including history of litigation. Full stop. The petitioner, the original petitioner, was serving as an assistant manager accounts in the co-party branch of the respondent bank when a disciplinary proceeding was initiated against him via a charge sheet dated 14/12/2012. Full stop. On completion of the inquiry, comma, inquiry, comma, a second show cause notice was issued by the disciplinary authority, whereby the findings of guilt of the petitioner was already concurred with. Full stop. Though reply was filed, comma, an order of penalty dated 24/9/2013 was imposed, by which the petitioner was dismissed from service and his gratuity was forfeited. Full stop. The appeal of the petitioner being rejected, comma, he had approached this court by filing WPC 3941 of 2014. Full stop. In the said proceeding, comma, there was under the said proceeding had culminated in an order dated 4/8/2015 passed by this court, whereby the impugned penalty order was set aside. Full stop. However, a de novo inquiry was directed to be conducted, and the petitioner would be continued to be under suspension. Full stop. Pursuant to the said order, comma, new inquiry officer and presenting officer were appointed, and the inquiry was conducted, which culminated in a report dated 24/12/2015. Full stop. The second show cause notice was issued to the petitioner on 31/12/2015, in which, however, the disciplinary authority had made an observation that the allegations were found to be proved. And observation that he was in agreement with the views of the inquiry officer, and the allegations were and 5 out of 6 allegations were held to be proved, and 1 allegation was held to be partially proved. Full stop. Para 3. Dr. Sharma, the learned counsel for the petitioner, has submitted that the entire procedure adopted, including those in the inquiry, are not in accordance with law, and there has been gross violation of the norms and fair procedure. Full stop. As regards the inquiry made, comma, it is submitted that no witnesses were examined, and though one person, Uttam Kalita, was subsequently named as a witness, comma, he was not examined, and therefore the question of not cross-examining him, and the question of cross-examining him also did not arise. Full stop. It is submitted that all the allegations which are apparently serious in nature were held to be established without the same being proved in the inquiry by competent witnesses. Full stop. Para, on the aspect of the procedure adopted by the disciplinary authority in issuing the second show cause notice, comma, the learned counsel for the petitioners has submitted that such second so cause notice has become a mere formality inasmuch as the delinquent officer was deprived of a fair opportunity to make an endeavor to convince the disciplinary authority to take a view other than the views expressed by the inquiry officer holding the delinquent to be guilty of the charges. Full stop. By referring to the notice dated 31/12/2015, comma, it is submitted that the disciplinary authority had agreed with the views and had also come to a finding that the allegations were proved. Full stop. Under such circumstances, comma, the scope of submitting a written representation was absolutely obliterated as the disciplinary authority had already made up his mind on the establishment of the guilt. Full stop. Para, in connection and in support of his submission, comma, the learned counsel has relied upon the cases of number 1, Union of India versus Mohammad Ramzan Khan, reported in 1990 by SCC. Number 2, 1993, 6 SCC.
I have AIR 1994 SC 1074.
No, 1993, 6 SCC ni 6 SCC 737. MDECIL versus B Karunakar. Sale Baba. 737 to hoye. Para. In the first case, comma, the Honorable Supreme Court was explaining the position after the 42nd Amendment of the Constitution of India, which had done away with the requirement of a so-called notice on the proposed penalty. Full stop. It has been held that though the aspect of proposed penalty is not required to be notified prior to imposition of the same, comma, the requirement of forwarding the views of the inquiry officer in case such inquiry is done by an officer other than the disciplinary authority would still be a mandatory requirement. Full stop. The aforesaid position has been clarified by the later decision in the case of MD in the case of B Karunakar by holding that the proposition laid down in the case of Mohammad Ramzan Khan would be prospective in nature from the date of the judgment, that is 20/11/1990, full stop. It has also been laid down that a delinquent is required to plead the aspect of prejudice suffered by him due to non-furnishing of the inquiry report. Full stop, para. The learned counsel accordingly submits that the impugned on the aspect of forfeiture of the gratuity, comma, it is submitted that such forfeiture cannot be done, has been done without following the due process of law. Full stop. The learned counsel accordingly submits that the impugned order of penalty is liable to be interfered with and the service benefits of the original petitioner be released to the present petitioners along with the gratuity amount. Full stop, para. Sri Gorgohai, Buragohai, learned counsel for the respondent bank has produced a photocopy of the records of the disciplinary proceeding. First of, it is submitted that there is a finding that the original petitioner was satisfied with the inquiry proceedings. Full stop. The learned counsel for the bank has also tried to defend the second show cause notice dated 31/12/2015 by submitting that such agreement was tentative in nature and the petitioner, original petitioner, was given adequate opportunity to make his representation. And by such tentative agreement, the proceedings would not be vitiated. Full stop. Para. The rival submissions have been duly considered. Full stop. Para. As observed above, the importance of furnishing the report of the inquiry officer to a delinquent before the same is acted upon by the disciplinary authority has been clearly laid down by the Honorable Supreme Court in a category of decisions, including the above referred to cases. Full stop. It has also been clearly laid down that while the requirement of informing the delinquent of the proposed penalty has been done away with by the 42nd Amendment of the Constitution of India, the requirement for having the views of the delinquent before concurring with the findings against such delinquent by the inquiry officer would still be an essential requirement. Full stop. Para. What is intriguing in the present case is that in the earlier round of litigation, namely WPC 3941/2014, the earlier order of penalty dated 24/9/2013 was interfered with on the same very ground, Full stop. This court has also noticed that in the earlier judgment dated 4/8/2015, this court had recorded the submission made on behalf of the respondent bank that the inquiry was not conducted in accordance with law. Full stop. In paragraph 18 of paragraph 18 of the said judgment, the following observation has been recorded. Para. After the remand by this court with a direction for holding a de novo inquiry, it appears that the same error of law has again been committed by the disciplinary authority. Full stop. Even without going to the aspect of the challenge that no witnesses were examined in the inquiry, which however has been disputed by the learned counsel for the respondent, the aspect of concurring with the findings of the inquiry by the disciplinary authority while issuing the second show cause notice dated 31/12/2015 is wholly contrary to the established procedure of law, which mandates a fair opportunity to a delinquent to defend himself. Full stop. In fact, in the case of B. Karunakar, it has been laid down that a fair opportunity to the delinquent is a vested right which emanates from the initiation of the proceedings till the completion of the same, including the appellate stage. Full stop. This court has also noticed that in the affidavit in opposition filed by the bank, respondent bank, in reply to the averments made in paragraph 16, comma, the following reply has been made. Page 132, paragraph 19. Huh? Full stop. The aforesaid stand taken by the respondent bank is a flawed stand in terms of the law laid down, as the disciplinary authority, before coming to a finding of agreement with the report of the inquiry officer, is effectively required to have the views of the delinquent by giving him an adequate opportunity. Full stop. It would be a different matter if the inquiry officer, if the inquiry is done by the disciplinary authority himself, or that the delinquent chooses not to respond to the second show cause notice. Full stop. However, that is not the case in hand. Full stop. Para, with regard to the other aspect of the penalty, namely forfeiture of the gratuity, comma, the Payment of Gratuity Act, 1972 lays down that gratuity shall be payable to the employee on conditions laid down. Full stop. Under Section 4 of the Act of 1972, comma, subsection 6 is the only provision regarding forfeiture of gratuity, which essentially requires that the loss caused to the employer is to be ascertained, and only to the extent of such loss, comma, there can be a forfeiture. Full stop. There is no materials on record to show that any assessment in that nature has been done. Full stop. This court has also noted that the loss quantified in the proceeding was admittedly stated to be probable loss, and therefore, without there being a certainty of loss caused, comma, if any, comma, gratuity of the delinquent employee cannot be forfeited. Full stop. The mandate of the Act of 1972 regarding such entitlement of gratuity has been discussed in a catena of decisions by the Honorable Supreme Court. Full stop. Para. In view of the aforesaid, this court has also pondered the situation which exists now when the original petitioner, within bracket delinquent, has passed away, and therefore the scope of any further inquiry is practically not possible. Full stop. This court has also taken into consideration that on the remand of the matter by this court, wide order dated 4/8/2015, comma, a fair procedure was required to be followed in the de novo inquiry. Full stop. On the contrary, comma, from the pleaded case of the respondent bank itself, which has been mentioned above, comma, it appears that the legal position has not even been properly understood and comprehended by the respondent bank. Full stop para. In view of the aforesaid discussion and facts and circumstances, comma, the impugned five 2016, as well as the appellate order dated 2/12/2016 are set aside and quashed, full stop. Since the original petitioner, who was the delinquent, has passed away, comma, the present petitioners, the respondent bank is directed to release the what is this benefit, the CRG?
Pensional benefit.
Is it pension? He died. To release all benefits. He would not have superannuated. He was still in service. This is DCRG.
CCRT, regular monthly pay, commutation, GIS.
No, all benefits which would have accrued to the original petitioner.
If he dies.
He died, yes, which of original petitioner who had passed away on 5/11/2023 by 23, full stop. The gratuity, the aforesaid entitlements would also include the amount of gratuity, full stop. The entitlements be released to the present petitioners expeditiously and in any case within a period of 3 months from the date of receipt of a certified copy of this order.
Lordship, one more submission, Lordship. During the first round of litigation, court directed that subsistence allowance to be paid during the course of de novo inquiry. But what they have stated in the penalty order that the suspension period during the de novo inquiry, that is to be treated as not on duty. So he is entitled to suspension and subsistence allowance also.
No, not on duty also, you will get a say. Not on duty is only for salary.
Subsistence allowance not paid.
Pay the subsistence allowance.
Yes, record, your lordship.
It is submitted, Taravoti, it is submitted that even this, that in spite of the court's order, comma, the subsistence allowance were not paid to the original petitioner, full stop. The subsistence allowance is required to be calculated and paid at the appropriate rate to the present petitioners, along with the other benefits which has been directed to be paid. The photocopy of the records is returned back to the learned counsel for the bank, respondent bank.
Much obliged.
Item 10.
Lordship, kindly for the matter. My senior is.
Item 10.
Yes.
Who is your senior?
P. Bhuya.
Not well. Okay. 19 matter. Yes, when?
Next week, any day.
When, madam? Here for CCC. It is submitted that Ms. B. Bhuya, learned counsel for the petitioner, is unwell. On March also you have taken time. She is not well.
Yes.
What has happened to her? Actually not well or what?
Yes, Lord. Feeling.
23rd March she was not well, 2 weeks. Today we are in May.
Today not feeling well, Lordship, that's why.
Be here, senior counsel, be here. No. Oh. That is why we saw how we be here today in the court and suddenly she is not well. Thursday.
One more item, Lordship, item number 12 also.
Same matter or what?
Yes, no, Lordship.
Different matter.
Yes, Lordship.
Food Corporation, you're there. Okay, Thursday. Thursday. Okay. It is submitted. That means be here. Learned counsel for the petitioner is unwell. Full stop. Also heard. Your name?
M. Burman on behalf
M.
of.
Borman, learned counsel for the CGC. Or A to Diba? A. Chakraborty
Yes.
for the FCA. List on Thursday. Separate orders, huh? एक में दूसरा में चक्रवर्ती 12 में और 10 में M. Borman.
Hello.
11. A will not become SK. A will remain A. Yes.
There was an advertisement, Lordship, for filling up of the post of Gavura of charge number 16 under Conversia Revenue Circle, Lordship.
Yes.
Page 16 is the first advertisement, Lord.
Then?
And Lordship, I applied for that. Thereafter, subsequently, another advertisement was issued on at page 19, Lord.
Okay.
By which since I have 3 children.
Yes, you have
Lordship,
got instructions.
We file affidavit, Lord, you may kindly see in our affidavit. Is that we have annexed that notification dated 19/7/2019, Lord. In the state notification, it is said that, my lord, that the provision should not be applicable in respect of those persons who have more than two children prior to date of communication into force in the notification dated twin.
Okay,
My lord, he already been applied. It is come to force on, my lord, in 19/7/2019. The advertisement was, my lord, issued on, my lord, 2018. He already been applied. No, he is not, he is eligible for, my lord, to appear in the interview, lord. This the notification will not, my lord, affect to this, my lord, petitioner.
So you should advise your client, consider him.
In the advertisement, lordship, it is itself, my lord, stated, lordship, my lord, kindly see the serial number 12, lord.
Page
22.
22.
Lordship.
This is the advertisement.
This is the
second advertisement that subsequent advertisement.
Subsequent advertisement.
Page 22, lordship, my kindly see. Serial number 12, lord.
Serial 12.
Lord. The applicant who have submitted application in terms of the so-and-so dated 27/6/2018 are not required to submit application again, but they have to require to submit information mentioned in the clause 10 and 11. My lord, they have to, my lord, submit, my lord, that information they have to, my lord, given.
Yes.
Question number, he is not eligible, is does not arise, my lord. As far as
No, you have 3 children.
Yes, Lord.
only he have to, my lord, that submitted, my lord, that affidavit. There he have a, my lord, he has a, my lord, that receipt. My lord, this notification of 19, it was affected on the date of from the
19/7.
notification is, my lord, that I,
Which notification?
my lord, that I have annexed in my affidavit, lordship,
Page?
page 7, lordship, internal page 7, lordship, annexure A. 19/7/2019 notification, lord.
31. 19/7.
2019 is published in a gazette,
Yes, what?
gazette notification on
Children up
2nd
to
August
living children.
2000.
Yes, what is this?
Lordship, my lord, kindly see that serial number 1 in
9, 11.
11, lord.
You should not have two or more children.
Lord. Next, lord, provided that this provision should not be
Should not have more than
applicable
two children.
in respect of those persons who have more than 2 children prior to date of coming into force in this notification.
Okay.
So this prior to this notification, my lord, this application is not applicable. My lord, that the advertisement was issued on, my lord, 2018. It's come on, my lord, in force on 2nd August 2019. Lord.
See, the bar of being disqualified for having two or more children came into effect from 19/7/2019. And this process is of 2018.
2018, Lord.
So why was the information required to be given under clause 10 and 11 and an affidavit?
My lord, this was given, my lord, subsequent, my lord, that it was given, my lord.
Not subsequent. See, this gazette notification is of July 2019.
Lordship.
No problem. Now in the advertisement, second advertisement.
Lordship. My lord, might have, my lord, in the first my lord, advertisement, there is a less number of, my lord, that application has been, my lord, submitted. My lord, that this is the, my lord, that for the post of Gampura. My lord, that particular, my lord, that lordship, they have to, my lord, minimum, my lord, that application should be, sir.
In principle, provided this will not be applicable in respect to those persons prior to that. More than two children. What is the meaning of this proviso? Mr. Dhar, provided
that this provision should not be applicable in respect of those persons who have more than two children prior to the date of coming into force of this notification dated 19/7/2019. From 19/7/2019, it will come into force now. And prior to that, advertisement was issued on 8/11/2019. Therefore, I'm eligible for
8/11. Advertisement when?
Advertisement, lordship, earlier advertisement was on
27/6/2018.
27/6/2018.
18. Was
origin advertisement.
Yes, Lord.
And second one?
08/11/2019.
Eight 11/19.
Lord.
And what is your case? You applied?
Yes, I applied it.
Then?
And submitted all the required documents,
Then?
lordship. And since the second advertisement was issued, I have been made ineligible.
Ineligible. Then what has happened to the process?
Due to three children, Lord.
No, what has happened to the process now?
Now, lordship, I am not aware whether
Now, what is the status of the case?
whether the interview has been held or not, lordship, I am not aware.
No, if the interview is held and somebody has been appointed, what relief can we give?
It's certainly don't have to.
Somebody has been appointed, lordship, but they have to go for the 162C, Lord.
Then yes,
No, some appointment made, we may not straight away per se find fault with that. But yes, his case not been considered is an aspect, but that will not automatically will lead us to interfere with somebody's appointment. His appointment is not under challenge.
No.
No.
And even then,
In this matter, we could not finally dispose of in time. When matter of which year?
2019, Lord.
19, Mr.
Only
Kaur.
after that, 3 days, this matter has been listed.
You should have,
They should have mentioned.
was there any interim order?
Yes, Lord.
The interim order, what?
Only
is-
one of that advertisement.
Advertisement was
That
still
advertisement was received.
Oh, that means no
Just
problem,
suspended.
no appointment.
No, my lord, advertisement was suspended. My lord, that the person who have, my lord, have more than three, my lord, children. Then he will, my lord, that person will be the non-eligible for the, my lord, for the,
No,
appear in the select.
Interim order till then, 24/1/2020. What is 24/1/2020? Hmm? Oh, no, not 24, 8/11.
8/11.
8/11 was suspended.
But that was suspended.
So he has a fair chance. If you have not gone ahead with the advertisement, hold him to be eligible, consider him with other candidates. Okay. बहुत जल्दी जल्दी लिखो। A short controversy has arisen in this, has been raised in this petition filed under Article 226 of the Constitution of India pertaining to selection and appointment of Gaon Buda of charge number 16
Yes, Lord.
under
Kalgasia.
Kolgosia Revenue Circle in the district of Borpeta. Full stop. An advertisement, a recruitment process was initiated via an advertisement dated 8/11/2019.
27/6/2018. First one.
Okay, 27/6/2018, issued by the Deputy Commissioner. Full stop. The petitioner, who claims to be eligible in all respects, had offered his candidature. Full stop. Subsequently, comma, there was a clarification via notification dated 8/11/2019, whereby a clause was introduced with regard to filing a declaration regarding the number of children of the prospective candidate. Full stop. Such notification was issued in view of the such notice was issued in view of the Gazette notification dated 19/7/2019, whereby certain amendments were made to the executive instructions number 162 within bracket 1 and 162-A in the Assam Land and Revenue Regulations pertaining to appointment of Gaon Buda. Full stop. As per the said amendment, comma, no person would be eligible for such appointment if he or she has more than 2 living children from a single or multiple partners. Full stop. Para. The Harthree, Ardhar. No, excellent. It is the contention of the petitioner that such amendment would not affect his candidature. Full stop. Para. I have heard Sri Ardhar, learned counsel for the petitioner. Full stop. I have also heard Sri C.K. Sharma Barua, learned state counsel, and Sri G. Handik, learned standing counsel, revenue department. Full stop. Sri Dhar, the learned counsel for the petitioner, has submitted that the eligibility of the petitioner has to be evaluated, has to be examined from the aspect of the date of the original advertisement, which is 27/6/2018, and any subsequent notification cannot change the eligibility criteria. Full stop. He has also informed this court that an interim order is in operation regarding the impugned advertisement dated 8/11/2019. Full stop para. Sri Handik, the Learned Standing Council, Revenue Department, has, however, submitted that the apprehension of the petitioner with regard to the advertisement dated 8/11/2019 may not be correct. Full stop. He submits that the Gazette notification dated 19 July 2019 itself clarifies that the embargo inserted with regard to the factor of having more than 2 living children would not be applicable for those persons who have more than 2 children prior to the date of coming into force of the notification, that is i.e. 19/7/2019. Full stop. It is the Standing Council accordingly submits that because of the advertisement in question dated 8/11/2019, comma, the eligibility of the petitioner would not be adversely affected. Full stop. Para. Sri Sharma Borua, the Learned State Council, endorses the views expressed by the Standing Council of the department and submits that because of the interim order, comma, the recruitment process have been put to a halt. Full stop. Para. Considering the aforesaid facts and circumstances and the submissions advanced, comma, this court is of the opinion that the Gazette notification dated 19/7/2019 has itself, while inserting the embargo of in the form of a disqualification for a candidate having 2 or more children, has itself clarified that such embargo would be effective prospectively from the date of the notification, which is 19/7/2019. Full stop. The original advertisement for the recruitment process in the instant case being of 27/6/2018, comma, the subsequent notice dated 8/11/2019, comma, in the considered opinion of this court would not have any bearing on the eligibility of the petitioner if on the aspect of the aforesaid embargo, if otherwise the petitioner is found to be eligible on other aspects. Full stop. Para. In view of the above, comma, the writ petition is disposed of by directing that the aforesaid aspect of in the aspect of disqualification relating to disqualify on the ground of having two or more children would not be applicable to the petitioner. Were the advertisement dated 27/6/2018 and his candidature may accordingly be considered at par with other eligible candidates, full stop. The authorities, however, are required to look into the other eligibility aspect of the petitioner while assessing such candidature, full stop. It is further made clear that the aforesaid consideration is to be made in case the recruitment process was not finalized before the stay order was passed on 19/12/2019, full stop. In case the process is still at a standstill, comma, the same be concluded expeditiously and appointment of the concerned Gaombura of charge number 16, Kolgacia Revenue Circle, Barpeta District be expeditiously made, full stop. The interim order dated 19/12/2019 stands vacated to facilitate the completion of the aforesaid process. Rest dates will be given.
Firstly, there is an interim order in item 32 and item 48 series matter. That may be considered.
32 for एक बार देख लीजिए interim order. Date to
Item
deliver.
32 और 48 to
What is-
54.
Item number 46, this is the matter where another three anomalous matters are also involved. So let me be listed next week, my lord, all the three, four matters.
My lord, item number 20, my lord.
Which item? Item number?
46.
Have you mentioned there 46?
Yes, I have mentioned.
Ah, I'm sorry.
My lord, item number 20, my lord. Petitioner wants to withdraw, my lord.
20.
Right, 20.
Who's for the government?
Yeah.
Anyone? Department, government withdrawal. State Council. কোন ছিল এই মাত্র? আরে CK Sharma Bura. SOC Learned Council wants to withdraw. CK
But
Sharma
for
Bura.
item
Dismiss for withdrawal. Dismiss for withdrawal. Yes.
Liberty, liberty.
What liberty?
My lord, if their case, actually, commotion case, my lord, they are considering, my lord. So,
It is needless to state that in the event any fresh cause of action arises, the petitioner
Right.
may approach this court.
Right.
Yes,
Okay.
Mr. Sharma.
Lordship, so far item number 30.
Your item, Mr. Hawk,
item number 20.
20.
Item number 33, Lordship, that matter which relates to appointment of its in-charge director in the Directorate of Geology and Mining. It has dragged on, my lord. If I pray, my lord, Lordship, that may be fixed.
They will give a date.
Lordship, I beg to mention item number 62 on behalf of Mr. H. Rahman, being Senior Advocate, regarding the provincialization of the retired employees from the municipal board, my lord. Mr. H. Rahman will be going for his medical checkup next week. So if a date gives.
No, he'll give dates. For dates, court
Item-
master will
This
give.
week, my lord.
Any matter where interim order is still today.
Item 18 and 19, there's an interim order.
18, 19 interim order. Okay. Rest dates will Mr. The court master will give.
Nada.